All right, folks, I'm going to call the meeting to order. As required under the Planning Act, a public meeting is being held prior to the committee making a decision on these applications. And for the benefit of everyone here, we live stream the meeting on our YouTube channel, and the recording is available after the meeting. Because meetings are accessible to the public in all of these ways, video or audio recording by members of the public is not permitted in the council chambers. This is to ensure that all attendees and those who come to make a deputation feel at ease. Thank you, and we appreciate your cooperation. Start things off, I'll introduce the Committee of Adjustment. I'm Mr. Robertson. We've got Mr. Strangway, Mr. Finn, Mrs. Archer, Mr. Richardson, Mr. Erickson, and online we have Councillor Yeo. All right. And staff in person, we have the Director of Development Services, Ms. Barry. We have the Acting Development Supervisor, Ms. Evans. Mr. Shahid, Planner 2. Mr. Okawat, Planner 2. Mr. Lahaye is our Secretary Treasurer. We have Mr. McKinnon, the Supervisor of Plans, Review, and Inspections. And last but certainly not least is Ms. Crockford, who is our Recording Secretary. All right. All right. Are there any questions or comments with respect to the agenda as printed? All right, being none, can I get a motion to adopt that agenda? Mr. Strangway? Do I have a seconder? Mr. Erickson? No further comments or questions? All those in favor? Well, we'll do it. I can do it all in favor for that. All right, all those in favor? Thank you. Just to let you know, we're going to be going with a recorded vote because of the fact that Councillor Yeo is online. So be prepared for that each time. All right. Are there any declarations of pecuniary interest? Being none. The minutes of the previous meeting, are there any comments or questions before I ask for a motion? All right, being none. A motion for those minutes. Ms. Archer, Ms. Richardson. Any further comments or questions regarding the motion on the floor? All those in favor? And that carries. All right. So from here on in, we're recorded vote. All right. For the benefit of everyone here and online, the committee will hear comments, gather information, and may ask questions to clarify statements made. The committee may ask and answer questions or redirect questions to the appropriate person. Please note that any information or comments given to the committee during this meeting, those are considered evidence. We will first hear from staff, then the applicant or his or her agent. We will then hear from any person in support of or from those who have questions, concerns, or are opposed to the application. Finally, the applicant or his or her agent will have an opportunity to respond to any of the statements made to the committee. Now, I would advise that if you wish to speak and you're here, please raise your hand and I will ask you to approach the podium. There is a button there that creates a red light on the speaker, and then we can hear what you have to say. Please state your name and then I will advise you to go ahead. If you're online, once you come on screen, again, I would appreciate it if you would give us your name so that we'll know who we're proceeding with. I would advise that we do afford everyone 10 minutes to make their presentation. I don't think we've ever had anyone here that's gone to 10 minutes. But if you find that you just can't possibly get all of your information in within those 10 minutes, then I will ask the committee if they will afford you a couple more minutes. But as I said, I don't think we've ever had anyone go that long. And if you do take some time, I will let you know when you're approaching the 10-minute mark and ask you if you would sum up. So just so everyone's clear. All right. Having said all that, and before I go further, I'm assuming everyone is probably signed in at the back corner there. If you haven't, we would appreciate that you do that prior to leaving. Thank you. All right, now back to the agenda. We're now dealing with file number D03-2022-010, and this is 26 Edgewood Drive, Geographic Township of Verlin, Director Barry, go ahead, please.
Thank you, Mr. Chair. Members, in most cases, the Director of Development Services, through their delegated approval authority of council, renders decisions to approve consents. On occasion, a consent application may be brought to the Committee of Adjustment for a decision. This would be the case in the 4 instances on the slide, when a consent application is a companion to a minor variance application to be heard simultaneously for processing efficiencies, or if staff are recommending denial of a consent application, or in the opinion of staff, agencies or public concerns can't be reasonably mitigated. And finally, if the proponent doesn't accept one or more draft conditions of provisional consent included in the staff recommendation letter. The consent application is being presented to the committee under the bolded 4th criteria because the owner does not accept the city's standard condition to pay the established parkland dedication fee. So this is relatively new business to some members of the committee, so we'll take some time and explain sort of the context for the condition as well as the application, and of course I'll be available for questions as needed. So through the staff report and my comments throughout this presentation, the fee is referred to as the cash in lieu of parkland dedication rate, or CIL, the acronym for cash in lieu. The legislation governing the severance of land, being the Ontario Planning Act, authorizes council to collect a percentage of land from the proponent to be dedicated for park or other public recreational purposes. It isn't always necessary or appropriate to collect the physical land from the property that is the subject of the development, and so the Planning Act also authorizes council to collect a payment in lieu of or instead of collecting land. To be clear, council has set the CIL payment rate through official plan policy, and that's noted on page 7 of our staff report. And only council has the authority to adjust that payment rate. Although the owner disagrees with council's CIL rate and the applicant has offered the committee a different interpretation of the legislation, as well as the approach to calculating council's CIL rate through their written submissions to you, the rate cannot be adjusted by this committee. If the committee decides that the consent application has merit and should be approved, then the committee is next responsible for deciding whether the conditions as presented by staff are appropriate or not. The committee can remove conditions. The committee can add conditions. The committee cannot change the content of particular conditions, and that includes the cash in lieu rate. The CIL condition is always included in applications as this one. And council expects that decisions made through their delegated approval authority, either through the director or through the committee, maintain this standard every time. The province has also upheld the position of the city with respect to the CIL rate in past board orders that we have reviewed in preparing for the public meeting today. So we've established that the CIL rate isn't debatable. But because the applicant hasn't signed back their endorsement of staff's recommendation for approval of this consent application with the conditions as drafted on page 13 of our staff report, I am obligated to present the application to the committee for a decision. So as noted in the staff report and in both previous staff recommendation letters from December 2022, and that's on page 16, and from March 2023, and that's on page 21 of our staff report, we recommend approval of the consent application along with the conditions of provisional consent that are on page 13 of our report. In my professional planning opinion, the application and the conditions have merit because they uphold applicable provincial and municipal land use policy, and they meet the intent of the zoning bylaw. Although some concerns have been raised by neighbors, we feel they can be mitigated, and I will touch on those in just a few moments. Overall, the application and the conditions are in the public interest, and for those reasons, I'm recommending approval. The subject lot is 26 Edgewood Drive in Verulam. The purpose of the application is for a lot addition that will create a new residential building lot as a result. The proposed severed parcel is approximately 7,941.6 square meters and is to be consolidated with the abutting lands to the south left orphaned from an unfulfilled severance back in 2005. The proposed retained parcel is approximately 6,570.9 square meters. Private water and septic systems are the form of servicing the lands, accessible by a year-round municipal road. The lot to be enlarged contains the owner's home, boathouse, a deck, and dock. The resulting new lot contains a boathouse and dock, and is anticipated for a new single detached dwelling in the future. If you're not familiar with this section of Edgewood Drive between Pleasant View Drive to the northeast, and Hickory Beach Road to the southwest, these images give you a sense of a heavily treed, low-density residential character of the area. The upper image is looking north at the edge of the driveway at 26 Edgewood Drive on the right, while the lower image is further north along Edgewood Drive along the frontage of the proposed retained lands, still on the right. From a policy perspective, the enlargement of one lot and the creation of a new building lot conforms to the rural area policies of the provincial planning statement as they relate to policies for residential uses, services, and the protection of natural heritage features and hazards. As noted by the pink color on the left map, the official plan designates the land's waterfront and permits low-density residential uses. The conditions have been prepared to ensure that the park's policies are implemented. The Verulam zoning bylaw permits single detached dwellings in the residential type 1 special exception 9 zone on the right map. With the exception of lot area, the proposal upholds all the other zone regulations. Just some zoning history. The R19 zone was put in place in 1990 to facilitate the creation of 5 new residential lots across just under 6 hectares with a minimum lot area of 9,000 square meters. Then in 1996, further subdivision of the lands necessitated a further reduction of lot area to about 4,000 square meters as a minimum, but that new R114 exception zone did not extend to include this subject lot at that time because it wasn't subject to further severance at that time. So flashing forward to present day, although a new building lot is the ultimate result of the application, the proposed severance isn't adding an additional lot to the overall lot fabric or inventory. There are 2 parcels there today. The application is enlarging the size of one parcel and reducing the size of another. So still only 2 parcels, albeit reconfigured. The proposed lot areas remain substantially large and exceed the adjacent required minimum lot sizes of 4,000 square meters. Both the new lot areas as well as the remnant standalone boathouse and dock accessory structures on the retained lands will be addressed through a future rezoning application as a condition of provisional consent. The discussion of lot area and future new residential use is perhaps a good segue to summarize the results of consultation. There were no concerns flagged by any of the commenting agencies. There were 2 surrounding landowners on Pleasant View Drive that had identified concerns over the future use of the land. Should a large building be placed near their shared lot line? Their concerns were over drainage, contamination impacts to their wells, to impacts from air pollution, noise, including construction noise, a sense of overcrowding, a loss of privacy, as well as a loss of trees. I have carefully considered the concerns raised and spoken with the neighbors a number of years ago, and I conclude that the zoning bylaw, as well as the Ontario Building Code, do contain appropriate safeguards and provisions to buffer the new development from the existing surrounding residential uses. In particular, according to our supervisor of Part 8 sewage systems, who conducted a review of all the properties along Pleasant View Drive, as well as their wells, the new property, this would be the retained lands, the future building lot, can support a sewage disposal system near Edgewood Drive while maintaining the minimum clearance distance for the neighboring wells. The restrictions on clearance distances may limit the level of development or the type of sewage system, but those parameters would be confirmed through the sewage system application process once that is submitted to support construction of a new house. The balance of the staff report contains excerpts of relevant legislation and a file summary from 2021 when this application was first filed with the Planning Division. We certainly acknowledge the timeline on this file and really do appreciate the owner's patience through a number of staffing changes and other challenges that caused processing delays. With our apologies, these have been explained to both the owner and to the applicant, as have other available options to advance this application to a decision, including the owner's appeal rights to the Ontario Land Tribunal. So with all that said, Mr. Chair, my presentation comments will come to a conclusion, and I will remain available to answer any questions that you or the committee members have. Thank you.
All right, thank you, Director. Are there any questions of the Director? Yes, Mr. Erickson, go ahead.
For the chair, could you specify which is the retained parcel?
Have we got a pointer so that we can be more clear as to what is where, please?
Okay, it's very light, but if we take a look at where the pointer is, outlined in green, the map on the left, here's the word retained, severed being the lands in red that contain the existing dwelling, and this narrow parcel here being the benefiting lot, which these severed lands would be consolidating with, as we see here. Without the distractions of all the features on the map on the right, I'm now pointing to also what would be the retained or the new building lot.
Mr. Erickson, follow-up?
And the cash in lieu would be, or the land itself would be 5% of the retained parcel, correct?
Director?
Sure, through you, Mr. Chair, that's right. Mr. Erickson, it is the value is stated 5% on the official plan policies, and that is on the developable lot, which is the retained in this case.
Follow-up?
And that value done by an appraiser, the maximum value that could be requested is up to 15%.
Mr. Chair, through you, our official plan limits, as does the Planning Act, that the percentage maxes out at 5%.
Through the chair, last question. You are asking for cash in lieu of 5%. Also in the legislation, it stated that no appeal shall be permitted if the base rate is used, the base rate being 5%, correct?
Mr. Chair, through you to the member, ultimately, an appeal can be filed for any purpose, and it isn't on staff's responsibility to vet the appropriateness of the appeal. We understand that the nature of the appeal is not with merit, if that's what the nature of the appeal was, but ultimately that would be with the tribunal to determine the appropriateness of an appeal of that nature.
Further questions? Yes, Mr. Strangway, go ahead.
Thank you very much, Mr. Chairman. Ms. Berry, one of the things you mentioned, I don't know if I'm taking it out of context, excuse me, are we creating a new lot? At one point you said there'd still be 2 lots. So are we actually creating a new lot, or are there still going to be the same number of lots there?
Can we go back to the pointer, Director?
We certainly can, thank you. And through you, Mr. Chair, currently, the entirety of the green and the red forms one parcel, and this orphaned sliver of land forms a second parcel. And as a result of the transaction, the red and the narrow benefiting merge to become one, and the green becomes the second. So there's one large holding and a second narrow holding, and the reconfigured lot configuration still remains at 2, but with a parcel that is smaller to the north and larger than what currently is this narrow sliver, because it would be added to the red.
So in theory, there's still 2 lots there.
In theory and in practicality, 2 lots today, 2 lots tomorrow.
Okay.
2 lots of a different size. Mr. Chair, sorry, add that in.
Would it be fair to say or not fair to say we're not creating any new lots then?
We are creating a new building lot. We are not creating an additional lot, adding to the city's overall lot fabric or lot inventory. So if there were 100,000 lots today, there would be 100,000 lots tomorrow. There wouldn't be 100,001 lots as a result of the consent. A shifting of lot lines, not adding to the inventory.
So in light of that, what does that say about charging for this fee for in lieu of parkland?
Mr. Chair, through you, thanks for the question. Yeah, it's a great one. It's based on the developable area. So if we're creating a new potential development, which we are by adding to a dwelling unit, and therefore needing to provide that extra park space or public recreation space for new occupants of a new house that was not contemplated through the previous subdivision of the lands and the lots in the underlying plans of subdivision, that is entirely the basis for the council's authority to collect cash in lieu of parkland in this case.
When this subdivision was created, was there not money set aside for parkland?
Mr. Chair, if I can draw the members' attention to the report, we go into a brief discussion on the historic development of the underlying plans. There is more than one. And so by way of background, the creation of Lot 95 on the registrar's compiled Plan 551 was prior to the present legislation, being, of course, the Planning Act, and that Planning Act is as of December 31st, 1990, and that is the date on which the city's cash in lieu rate is based. The creation of Part 6 on a reference plan 57R-6090 transferred on August 3rd in 1990, and that reference plan was deposited in August of 1990. Again, it was prior to the present legislation on which the official plan policy for cash in lieu is collected. Finally, the creation of Lot 8 on the underlying plan of subdivision 57M739 may have contributed either parkland or cash in lieu, but The reconfiguration that's happening as a result of this application facilitates a 9th dwelling, which otherwise wouldn't have been permitted through the 8 lots for 8 dwellings in that plan of subdivision, 57M 739, rendering the cash in lieu appropriate to collect through this application.
In light of what you're recommending for this lot, what is the cash in lieu amount?
The owner has not provided an appraisal, and so that is an unknown amount. We anecdotally can share that waterfront lots have a range depending on their size and their buildability, for example. Surrounding uses, there are a number of factors that go into consideration of a professional certified appraisal report. I'll leave my comments there.
And I would advise committee that the cash involved one way or the other, or the value, is not part of our mandate. So I would ask that the question stick to the recommendations or the report that we have before us. The cash is not part of our, is not part of our concern. If the applicant is not happy with the rate that has been set, they have every right to approach our council, City of Court Lakes Council, and let them decide whether or not the price that's set is correct or not correct, but that is not part of our mandate here.
May I ask one more question? Is this a standard way for municipalities to operate, or does that vary amongst municipalities? For example, do some municipalities have a flat standard rate for in lieu of parkland?
Mr. Chair, through you to the member, there's any number of ways for municipalities to establish how they collect the payment in lieu. And so, yes, it is entirely possible for municipalities to set a fixed rate where appraisals are not required. They can be requested, but that would all be subject to a council policy and embedded in official plan policy as well. We did quite a bit of research, not just for this application, but in our attempts moving forward to examine and assess how cash in lieu has been collected and what we would like to offer to council as a potential opportunity to reevaluate this as a program. That work was started, but it has been paused until a more appropriate time when we've got the staff resources to focus our efforts in that field. Part of the history of the cities, as well as County Victoria and the lower tier municipalities, already indicates that some of the lower tiers prior to amalgamation did have fixed rates. So there is some history in a handful of the former townships who elected under their councils of the day to collect cash in lieu under a fixed rate system.
Thank you, Ms. Berry, for that. That's all for right now.
All right. Are there any further? Yes, Mr. Finn, go ahead.
Just following up on those questions, Mr. Chair. I'm looking at the condition number 5, and this relates to the consolidation of the severed portion with the benefiting portion. And there's a requirement there to provide information as to the ownership of those two parcels. Is there any requirement that the two parcels be consolidated and a new deed be registered on title?
Through the chair, I've reviewed the condition 5, and thank you for the question through to the member. There would be an obligation for the owner's solicitor to demonstrate that the ownership is identical on both what is outlined in red on the slide at the moment, together with what's legally described as Part 1, that benefiting parcel, the narrow strip that is adjacent to it and abutting it on the south. The title would have to be identical, as I said. If the owner elected to provide a let me rephrase. The Secretary-Treasurer for the city would be applying a consent certificate to a transfer, a deed, transfer of land that included the legal description, combining the severed and the benefiting lots. So that stamped deed would be registered on title. That was a very long-winded way of just saying, yes, Mr. Finn, there would be a new transfer required that had the effect of, after registry, combining the benefiting and the severed lands.
So by the time the transaction is completed, there would then be two deeds on title, one for the retained portion and one for the severed and benefiting portion.
That's correct.
Okay, thank you.
Further from committee, Ms. Richardson.
Through you, is the benefiting lot currently a buildable lot?
Mr. Chair, through you to the member, it hasn't been evaluated by staff in terms of its buildability. We're familiar with the size, the zoning, but it has not gone through the sort of academic exercise of whether a traditional standard sewage system would be appropriately sited based on a number of factors: distance separation to surrounding wells, to property lines, to a potential building envelope, respecting setbacks, this sort of thing. So feasibility of building hasn't been assessed. If we take a look at the aerial, depending on how far you want to pursue sort of the inquiry here, it will just perhaps a little difficult to see, and we'll try to point with the laser. There are a number of limitations, and I mean, again, this isn't to scale necessarily, but gives you an indication of the size of a dwelling here and the size of a dwelling on the neighbor's property to the south, as well as their garage. In my opinion, it would be quite difficult to build within the regulations of the zoning bylaw.
So was that benefiting lot originally a right-of-way to the backlot owners then for them to have access to the water?
Mr. Chair, through you, originally the benefiting lot was part of, if you can imagine where my pointer is now, this formed what's known as Lot 7 on the underlying parcel fabric. Half of it was transferred to this property owner to the south, and ultimately what's today the benefiting lot was intended to be transferred to the current owner of number 26. So just to restate, if you can imagine an equal size parcel south of this heavy black line, and in fact, we may have a slide that helps represent that a little bit better.
So just
Similar, pardon me, to the member, if we look at the map on the left, Part 2 is just to the south of where you see Part 1 benefiting. That would have been the original whole Lot 7. So Part 2 transferred to the neighbor to the south, leaving the benefiting lot orphaned.
And how long ago did that happen?
Through you, Mr. Chair, the consent application is from 2005.
Okay, so it just seems odd that it would be approved that there'd be this small, narrow lot with, so the benefiting lot was just left as a small, narrow lot.
And so I'll just restate, and forgive me if this wasn't clear, the intent of severing was to have the benefiting lot transfer north, was to have it be added as we're doing today. That was the intention at the time, but it was unfulfilled. That was not completed as part of the transaction, which otherwise transferred Part 2, the south half of Lot 7, did transfer and merge on title to Lot 7 to its south. Forgive me, I think I referred to that central lot as Lot 7. It's in fact Lot 8. Back in 2007, the splitting of the lands south of the red parcel, the intention was half of it go to the neighbor to the south and the north half go to the owner currently today of 26. Half of that transaction took place, the other half did not. So it was not intended to be left as a standalone building lot.
So when we approve things like for different consents, et cetera, it's that if the condition is not fulfilled within X number of months, it's deemed not to be fulfilled. So why was that allowed to just lie? Why didn't they say, no, you can't have it?
It doesn't appear that there was a condition requiring that the lands merge the way that they were required to merge on the south. This could have been an oversight. There's really no way of telling. Really, the files are quite limited in their detail, but that is typically the result that happens when there isn't a specific condition requiring the merger, as there is today.
One more?
On a different strain. So the one letter of concern was that Lot 1 is concerned about the newly constructed house will be too close to his dug well, which is very low. So I know that the Mr. McKinnon's staff have been out there and they're saying it's okay, but there are concerns that the well could be impacted by any number of things.
Was that a question?
Well, yes. I mean, is it confirmed that the dug well will not be affected by all the construction, by pesticides, et cetera, et cetera, et cetera, that was addressed in the letter of concern?
Director?
Sure. So the comments from the supervisor of Part 8 sewage systems is confident in the building code requirements for construction of not only the new dwelling when that day comes, if that day comes, as well as the requirements for the sewage system. Now, based on separation distances that are required, clearance distances, there could be a need to limit the number of bedrooms, for example, or plumbing fixtures in the proposed new house. There also could be limitations or restrictions put on the type of sewage system that could be used to support that new dwelling. It could be something, instead of a traditional Class 4 septic system, an advanced treatment system, something that is more efficient, is smaller, takes up less physical space on the property. And anyway, those are two options that would be under review. When a day comes for that construction to take place. As far as pesticides go, this is not anything that's governed by the zoning bylaw or by the building code.
Last one, I think. I recall reading that the person who wrote, I think it's from lot number 1, said there's a roadway along the northern boundary of the retained lot. Is that true or not?
There isn't any indication that there is any type of municipal right-of-way that exists there. So in our opinion, that's perhaps how the neighbor characterizes that space. I understand that the applicant and the owner are in attendance for this meeting, perhaps can shed a little bit more light on what or if there is something representative of a trail or some sort of pathway on their private property, the owner of 26.
Ms. Archer, I saw your hand.
Thank you. I don't know if I'm going to be phrasing this properly, but the severed is going to the benefiting property. That's basically just cleaning up from 2005. And then actually what we're doing is just doing one severance, if you kind of put it that way, but a little simpler.
Sounds good to me.
Anything further from committee? All right. Being not, is the applicant here? Do you wish to speak to it, sir? If you hit the button there for the red light and state your name for us, if you would.
Doug Carroll, registered planner in the province of Ontario. Thank you, Mr. Chairman.
Thank you, sir. Go ahead.
We reviewed the staff recommendation letter from 2023, and we agreed with the recommendation, and we agreed with the conditions with the exception of the condition 5. And as a result of the passing of Mr. Pham, we asked that a minor clerical correction be made to, condition 4. And with respect to the passing of Mr. Pham last year, we respectfully request a minor change to condition 5, because in its current wording, we cannot fulfill it because title cannot transfer to Mr. Pham. We don't take issue with the cash in lieu dollar value. That's never been the issue. It was when the city said they were entitled to 5% of the appraised value of the land, which is not the formula the legislation prescribes. The legislation says, as been articulated here, the city is entitled to 5% of the retained land. The legislation goes on to say the city is entitled to the value of that area of the retained land. The value is determined by the qualified appraiser who uses the correct formula, which is consistent with the legislation. The appraisers have been perplexed over the last number of years with this type of an application because they appraise the value of the property based on the highest and best use being a residential lot. The highest and best use of the parkland was never intended for a residential lot. It's intended for public park use. So the appraisal that was recommended to us by the city to be done 2 years ago would have been flawed from the time it was researched and written. There's a difference in appraising agricultural land, waterfront land, forested land, scrubland, bushland. Recently, there's been a discrepancy between an appraiser in Port Perry and an appraiser in Peterborough. The appraiser in Port Perry, according to a planning consultant, understands the legislation and has used the correct formula. The appraiser in Peterborough does not understand the legislation and has not used the correct formula. One appraisal has to be redone at the expense of the property owner. So to recap the legislation, the city is entitled to up to 5% of the area of the retained land abutting the road allowance. I say abutting the road allowance because the public can't get to it if it's at the waterfront. So when you look at the calculations, approximately 328.5 square meters. Mr. Chairman, in Imperial, that's 3,536 square feet of area at the road allowance. That's what the appraiser has to look at. That's what the appraiser has to find comparables to in the countryside, here or wherever they can search the data. They come up with their appraisal based on that, not on vacant land sales of other rural residential lots or other waterfront lots, because the land, the 3,536 square feet, is intended for park use. I'm aware there's a old park in Sturgeon Point, because I used to attend that back when my godfather had a property in Sturgeon Point. It's still a public park. The appraiser has to do that type of research, find the parks in the area, find out what they've been assessed at by the the Municipal Property Assessment Corporation, and do the research and abide by the legislation. So we've agreed with the 5% land. The legislation does not say the property owner shall pay the city 5% of the appraised value of the retained lot. It says, as I put in my letter to you, require payment in lieu to the value of the land otherwise required to be conveyed. And the heading of that section in the Planning Act is conveyance of land for park purposes. It doesn't mention land to be severed. It doesn't mention land to be retained. It doesn't mention lots or blocks in a plan of subdivision. It says the land otherwise required to be conveyed, and that land is to be conveyed for public park purposes, not future residential purposes. So I've suggested to the committee that it consider an alternate condition 4 with respect to the city's required condition 4. I presume you have my letter dated May 9th this year, Mr. Chairman.
Sorry, I missed that.
I presume you have my letter dated May 9th to the committee. Thank you. Bottom page 4, sorry, condition 4 as required by the city, as recommended by the city, sorry, it's found at the bottom of page 1 and the top of page 2. It says the owner shall provide payment of the cash in lieu of the dedicated of parkland. That's correct. Equal to 5%. That's correct. Of the appraised value of the retained parcel. That's incorrect. That is not consistent with and does not reflect the legislation applicable to this matter. So if you take the requirements of the legislation, Mr. Chairman, and you put it in straightforward language, I've tried to do that in my proposed rewrite of condition 4, which is found at the bottom of page 4 and the top of page 5. The owner shall provide payment in lieu of the conveyance of land for park purposes, which is consistent phrasing with the legislation, to the value of the land otherwise required to be conveyed, also consistent with the legislation, being 328.5 square meters, which is arrived at by 5% of 6570 square meters. I neglected to include the 0.9 square meter in that calculation, so there may be some adjustment to that. Such payment shall be equal to the mutually agreed appraised value of 328.5 square meters or 36 square feet, as determined by an experienced and qualified land appraiser as of the day before the day the provisional consent was given. Alternatively, the owner shall provide payment of $3,500 in lieu of the conveyance of land for park purposes. Payments shall be made by a certified check, money order, or from a lawyer's trust account. So, Mr. Chairman, it's my opinion that my revised condition 4 is more consistent with the prevailing legislation than the city's interpretation of its policy. We're not asking for the dollars and cents to be addressed by the committee. We're asking that the equation be written as clearly as possible to reflect the requirements of the legislation, not the interpretation of council's policy written in 2010. If that policy written in 2010 had been written more clearly, more succinctly, I suspect we would not be here today discussing condition 4. Finally, with condition 5 on page 5, I requested it be revised as noted in the second last paragraph on that page. There were a number of questions with respect to the previous development of this property, Mr. Chairman. The benefiting lot is the north half of Lot 8 in that abutting registered plan of subdivision. That subdivision, the owner of that land who subdivided that property would have had to provide to Verlin Township cash in lieu or land for park purposes. I asked if that had been done, and as I don't have any access to the city's records provided to the city by the Ministry of Municipal Affairs and Housing, I have no answer to that question. When you go back in...
Mr. Carroll, I'm going to ask you, are you close to a sum up?
No, sir.
Well, how much time do you feel that you would need?
No more than 5 more minutes, sir.
Committee all right with that? All right, we'll give you 5 more.
Thank you. Attached to my letter, there's a survey showing parts on a reference plan of survey. Survey number is 6090, and it shows parts 1, 2, 3, 4, 5, and 6. I don't have access to the city's records, so I don't know if that survey was accompanied by consent applications and the status of those consent applications, if in fact they were submitted for processing by the county's Land Division Committee in concert with input from the Township of Verlin. If they were, cash in lieu would have been required by the Township of Verlin and submitted to the Land Division Committee, and the owner would have been required to pay that cash in lieu as a condition of getting the deed stamped for those properties. Or the owner would have had to convey land for public park purposes. Again, because I don't have access to those existing records, I can't answer the question. I can only tell you what my research has confirmed, that there were surveys done for severances, a registered plan of residential subdivision was deposited, registered lot sold off, and the township and the county would have required payment of cash in lieu and or any combination of dedication of land and or payment of cash. The area of the retained parcel is 6,570.9 square feet. I suggest that there's plenty of room to safely establish a conventional septic system, a typical dwelling, and a drilled well outside of any area of influence of the abutting services on lots 35, 36, 37, 38, 39, and lot 1, and the park block to the north of the retained land. There was a question also, Mr. Chairman, with respect to a road along the north limit of the property. The surveyor has determined that that is public road allowance, and that's why we are able to create this lot, because it has the frontage on a public road allowance. You'll see on the surveyor's sketch, he's delineated the edge of asphalt road, and so that represents the frontage of the retained land on the abutting public road allowance. I don't know if that's the portion to which the neighboring property owner referenced in their comments to staff a while ago. The confusion with the existence of the benefiting lot, I believe, has been established by an error on part of the registry office. The application filed by Mr. Grant on behalf of him and the late Mr. Pham with respect to Lot 8 was that the lot be divided in half. The south half would transfer and consolidate with Lot 7 being Mr. Grant's property, and the north half would transfer and consolidate with Mr. and Mrs. Pham's property to the north. When the surveyor did the title search, in doing the research for this sketch, he found that the registry office had assigned a separate pin to that deed. That was not the intent of that application, was not the intent of the decision of the city at that time, but that's a human error made in the registry office. This application intends to correct that, and that will address in part the concern raised by Mrs. Richardson. It is a separate building lot. A building permit cannot be issued because the zoning that's on the property today cannot be complied with, and you can't get a building permit if you can't comply with the zone provisions on the land. There is a proposed condition with respect to zoning that will address the retained lands and the severed and consolidated benefiting lot. We don't have any issue with that. I think I've addressed all the outstanding conditions, or sorry, concerns that I heard, Mr. Chairman. Thank you.
All right, thank you, Mr. Carroll. And before I go to committee, Director, do you have any response to any of the comments made?
No.
Committee, questions of Mr. Carroll? Mr. Erickson?
Through the chair, in your letter, beginning on the bottom of page 2, where it says the city's official plan, that's the start of the last sentence on the bottom of page 2. And then go over to page 3 under section S34.13 parks. Pursuant to the Planning Act, the city shall accept 5% parkland dedication or the equivalent in cash in lieu of parkland for residential. There it states where the land would not be suitable for parkland or municipal purposes, the municipality may accept a cash settlement equal to 5% of the value of the total proposal at the time of draft approval of granting a consent. In your own letter, doesn't that conflict with what you just stated, that it should only be a limited portion of land in the amount of 328.5 square meters?
Mr. Carroll, before you proceed, I'm just curious, what's happened to Councillor Yeo? I don't know if we've got him, we still got him online? I'd rather see him than a picture of the committee. No?
Thank you, Mr. Chairman. With respect to Mr. Erickson's question, I think he's quoted section 34.13, and I have 2 paragraphs quoted there. So I'm just quoting what's in the official plan, and I've already indicated that I believe that is unclear and not reflective of the requirements of the Planning Act with respect to the equation we're trying to clarify here. So pursuant to the planning, cities shall accept 5% parkland dedication. Great. The interpretation section says the numbers in the official plan are not absolute. Staff have said, you've got no authority, I've got no authority, no planner has any authority to make any changes to those numbers, notwithstanding what council's interpretation policy says. Any reference to quantities, such as lot areas or density of development, not only lot areas or density of development, but such as. And Mr. Chairman, I have seen a lot of these interpretation policies in a lot of official plans during my career. This is consistent with many of them. The interpretation is not consistent. The second paragraph under section 34.13 parks, where the land would not be suitable for parkland or municipal purposes, the municipality may accept cash settlement equivalent to 5% of the value of the total proposal. What does total proposal mean? Another vague, unclear phrase. If it had said the land otherwise required to be conveyed, it'd be more clearly written, more clearly understood. At the time of the draft approval or the granting of consent. We're on the same page, Mr. Chairman. We're disagreeing about the actual equation that implements the legislation and the slightly flawed official plan policy from 2010 when council adopted it. Unfortunately, I'm the only person in this room who was in attendance when the official plan was adopted. I don't think Mark was with us at that point. Thank you. So I can tell you that it went through a process that was incomplete with regards to proofreading and checking against applicable legislation because of the constraints imposed by council, both budget-wise and human resources back in 2010. And here, for the current planning staff, they are struggling with the same impacts on their ability to function and operate and serve council and the community. Lack of staff and lack of money.
Mr. Carroll, I would ask that we don't need another presentation, so would you be a little more succinct with respect to your responses?
Yes, Mr. Chairman. With respect to condition number 5, I would hope there is no objection to the proposed revision, which is as follows. The owner's solicitor shall certify that the landowners registered on title of the severed parcel, subject of this application, is identical to the landowner registered on title of the abutting parcel, with which the severed parcel is to be consolidated, being Part 1, RP 57R 9410. Thank you, Mr. Chairman.
All right, any further questions of Mr. Carroll? Yeah, Mr. Strangway?
Certainly challenging information, Mr. Carroll. Mr. Carroll, have you had an opportunity to sit down with the staff to work on the wording here and what's taking place? Is this the case that there has been communication between staff and yourself, or where are we at with that?
I did have a chance, my client and I did meet with city staff. We disagreed on the interpretation at the beginning of that meeting, and at the end of that meeting, we disagreed on the interpretation of condition 4. So we attempted to review the legislation, we attempted to discuss and deliberate to find the resolution. We weren't able to. That's the only reason why this matter is before you today.
During that discussion, was the city solicitor involved?
No.
I'll ask both yourself and Ms. Berry, is there any point in further meetings? Because I'm feeling here as a committee member, we're hearing two very different opinions. And, you know, it seems to be pick one, pick the other, and I'm struggling with this. And I would really wonder if obviously I'd love to see is come to some resolution rather than saying pick one or the other. And do you see any point, and I asked Ms. Berry as well, further communication between the two groups to try to straighten this out and to make sure that we get the right decision?
All right, before you respond to that, Mr. Carroll, let's go over to the director. I noticed in your report on the bottom of page 3 of 26 that you indicated that solicitors were involved. Was the city solicitor involved in those discussions?
Thanks for the question, Mr. Chair. Yeah, yes, absolutely. The city solicitor has been involved in many ways. as well as including reading, reviewing, and vetting the accuracy of the staff report, as well as the conditions, the official plan policy, and the application of council's cash in lieu rate. So in that regard, there is no confusion on the point of staff. There is no need for clarification from staff's perspective, including from the city solicitor. The interpretation clause in the official plan refers and is intended to apply to measurements and not to percentage values in this case. That's also clear, and staff have no confusion on that point. I'll reiterate, as I mentioned in my comments earlier, Mr. Chair, through you to the member, that the content of the condition is not subject to further adjustment by the committee. And both the owner and the applicant have been invited and encouraged to approach council through a deputation to bring forward their interpretation of the legislation. That has been shared with the city solicitor through myself on a number of occasions, and not just with the city solicitor, but we have canvassed a number of other municipalities, spoken with other planners and industry consultants, and stand by the clear direction in the official plan. Mr. Shangway, do you have another question about the point of the condition that's in question? And what I hope to achieve here is to help guide you in terms of the options the committee has available to them, and that is to keep the condition as it is, remove the condition if they feel that cash in lieu, no matter what the amount is, should not be collected on a new building lot. And of course, there's also the option of denying the application. And if there's any further, you mentioned the word struggle, and if there's a further clarification we can provide as to what the options you have, as opposed to sort of picking the position and recommendation of staff versus the submissions that are being made on behalf of the owner, allow me to help clarify that for you, that in our opinion, that isn't the task in front of the committee today.
Mr. Carroll, the question was originally directed to you. Do you have any response?
Yes, sir. The question was the solicitor at the meeting? The solicitor was not at the meeting that my client and I had with city staff in February. The city solicitor, according to what I just heard, did not review the legislation with respect to what the city is entitled to. I've already stated, Mr. Chairman, we agree to the 5%. We've not said we agree or disagree with any value, because no one has determined the appropriate value of the land otherwise required to be conveyed for park purposes. So we keep going around in a circle because the legislation says two things. I've tried to stay focused in my letter on those two things, provide you with an alternate condition that uses those phrases in an appropriate manner. There's been no challenge of that other than to say, we disagree. There's been no review of the city's policy in the context of the phrases in the relevant provisions of the Planning Act that apply to this.
All right. Go ahead.
Mr. Chair. Mr. Chair, over here. Thought I would call out, I wasn't sure that you could see the mic turned on. There was an indication from Mr. Carroll's comments that the city solicitor did not, at least that was what was understood from my comments, that the city solicitor did not review the legislation, either as a result of the written submissions or of the meetings that I had had and the discussions that I had had with Mr. Carroll. That is not accurate. The city solicitor has reviewed the legislation, and again, on receiving that information from Mr. Carroll, and we're confident in the recommendation that we've put forward to you, which is exactly the same as has been done for the last certainly decade and a half.
Thank you.
It has been tested, forgive me, through Ontario Municipal Board decisions, and the results have been in support of exactly what is being presented today. Thanks.
Mr. Erickson, who's your question to?
This will be a question. Could it be explained, the terminology, where it says in here, a municipality may require a payment in lieu of the value of the land otherwise to be conveyed? Okay, that's one part. On the proposed conditions of provisional consent, number 4, the owner shall provide payment of cash in lieu of the dedication of parkland equal to 5% of the appraised value of the retained parcel. And then the third one, in Mr. Carroll's letter on page 3, that I had stated earlier under section 34.13 parks, pursuant to the Planning Act, the city shall accept 5% parkland dedication or the equivalent, cash in lieu of parkland. And as Mr. Carroll also pointed out, where it says, where the land would not be suitable for parkland or municipal purposes, the municipality may accept a cash settlement equal to 5% of the value of the total proposal. Which term are we using here? Which of the 3 terms?
Director?
Thank you, Mr. Chair. So if we look at the first member's point, and that being the word otherwise, it sounds like is being sort of emphasized in that statement, we would encourage the committee to read that as instead of the option of. So if it helps, I will read the wording as it exists and then the wording as it's intended to be applied. The municipality may require a payment in lieu to the value of the land otherwise required to be conveyed. And now, here, the municipality may require a payment in lieu to the value of the land instead of the option of requiring that the land be conveyed. It is the act of doing so and not the portion or area of a particular parcel of land, be it 5432 or 1%. Okay. The developable lot is also understood in this case to be the retained. Very often, it is the severed land that is being transferred or conveyed from Party A to Party B or from Party A to Party A. It matters not, but it is agreed between both the owner through their applicant and us that in this case, a cash in lieu payment is appropriate for the retained parcel, given it is ultimately the new building lot. And we agree with the members pointing out language in section 3413 that the payment in lieu does apply to the entirety of that parcel, the total proposal. Thanks, Mr. Chair.
All right. Anything further? Mr. Erickson?
Clear. Has the Land Titles or Land Registry Office been consulted on this? And to help determine, as Mr. Carroll stated, was there a historical error committed in the past? Does it have anything to do, or did it confuse this item?
Director?
In our opinion, it doesn't confuse the item whatsoever, and it would not, also in our opinion, serve to help the members or help staff, or even we would offer the owner or the applicant to have the RO consult on a matter as this. We think that it is not relevant to what the consent application is requesting be facilitated.
Further? Ms. Archer? Who is this to?
This is just a statement in general, seems to me we're kind of going around in circles. We've got one side, we've got the other side, but our only three options are take it the way it's written, accept condition, I think it's 5. We can remove condition 5, or we can say no to the complete consent. I think those are our options. So I think all this other stuff we're talking about really isn't necessary.
Well, the only bad question is the one that doesn't get asked. So I'm a great believer in questions being asked and them being responded to. So
I as well, but none of them that we're asking have anything to do with what our options are.
yeah, well, we're talking about interpretations of things here. So I would ask you to reserve those comments if we get a motion on the floor, then. Strangway.
Thank you, Mr. Chairman. I hope you'll bear with me. Ms. Berry, the last few minutes ago, you had mentioned the applicant going to council for some considerations. Could you elaborate on just that aspect, please?
Mr. Chair, through you, sure. To the member, the ability certainly is there and continues to be there for the applicant or the owner to request a deputation to present this matter to council, because council is the only body who has the authority to make an adjustment to their established rate of collecting a payment in lieu. Council would then have an option which could include directing staff to undertake some further work, and that option again remains available to the applicant today and to the owner. Now, it should be, again, I'll restate, it is enshrined in official plan policy. So if council one day is to look at the potential of making a change to how the cash in lieu rate is undertaken, then it would require a public process, an amendment to the official plan, could also be requiring a new council policy and bylaw. So this will be time consuming and may not fall within, as lengthy as this process has been already for the owner, may not fall within their expectations on how to resolve this matter. And we think we've brought those options forward not only today, but a number of years ago as being the correct and appropriate way to deal with this matter.
Thank you for that. That helps a great deal. Just one further follow-up. If we were to go ahead and make a decision today, does that affect their ability to go back to council one way or another?
Mr. Chair, through you, it's an interesting question. Nothing prevents the ability of a deputant to approach council. There would be a process that follows a decision of this committee. That's the natural appeal period. So for 20 days, there would be an opportunity for any prescribed body or the owner to file an appeal against the decision or conditions that are set by the committee. And so there perhaps would be a question as to the timing of approaching council and making a request. And I'll sort of park that comment there. But if this helps committee in rendering a decision here, to Member Archer's comments before, that quite correctly, there is an option here for the committee to approve the application, to refuse it, to defer it, and then, of course, to add or remove conditions. And ultimately, if there was a decision by the committee to remove the condition regarding cash in lieu, that council, of course, would be notified of that action and would have an opportunity to reinstate the condition. It is, again, their expectation that the condition stays because it is appropriate and it is their direction.
for the committees, I think to some degree agreeing with Ms. Archer, I think we've beaten this up pretty good. And so I'm going to allow one or two more questions if you have them. If you don't, we're going to. Mr. Carroll, I've afforded you more time than we normally do to speak, so I don't know that I'm going to ask you or permit you to speak further unless there's questions. Are there any further questions of Mr. Carroll? We're good? All right. Thank you, Mr. Carroll. I appreciate you taking the time.
I have a question, Mr. Chair.
Yeah, I was going to ask you to kind of shout out because I don't always look up, Counselor, so go ahead.
Yeah, I just have one question, and I guess it to Mr. Carroll, seeing as he used to run the department and now he's in the private sector. The decision this committee is being asked to make today, it is one that shouldn't be taken lightly, and should we err on the side of what you're proposing, do you foresee the city having to go back on what they've done for the past decade and a half, and reconcile past amounts of money paid to the city?
Thank you, Councillor Yeo. Thank you, Mr. Chairman. Do I think there's if you agree with my proposed condition 4, is the city going to be exposed to reevaluate previous decisions respecting payments of cash in lieu? I don't know what other owners of lands, other applicants of consents or plans of subdivision condominiums will do, Mr. Chairman, Mr. Councillor. Most of those people are gone on with their applications, their developments are done. They don't even own the land anymore. Whether they want to pursue exposure, I'd just be guessing, sir. I'm sorry.
All right, and thank you for that, Mr. Counselor. Anything further?
No, it's just a hypothetical to see if you had any insight on something on that side of the argument. But nope, that's all. That's the only question I had, and it was strictly a hypothetical. So thank you for that.
All right, and thank you, Mr. Carroll. We appreciate you taking the time.
Just one further question, please, through you to Ms. Berry.
Did you?
Yeah, through you to Ms. Berry. I do. After that question, if it changed, as he suggested, as no. Mr. Yeo, Councillor Yeo suggested, would it affect future consent applications?
If I understand the question correctly, Mr. Chair, through you to the member, what I'm hearing is might it set a precedent, and if the committee was to make an adjustment to the CIL rate, my expectation, not just presumption or thought, but my expectation would be that every applicant with a cash in lieu condition would be requesting relief from the amount that's required.
I would advise the committee that decisions made here are not, I repeat, are not precedent setting. However, I think the director has indicated that depending on what happens here, she would very well go to council and see what their perspective is on whatever the decision was. So I'll leave it. All right. Anything further from committee? All right. Is there anyone here or online that wishes to speak in support of this application, in support of the application? Yes, sir. And your name, sir?
I'm Mike Perry.
Thank you. Go ahead.
Also the councillor for Ward 3, and I'm here on behalf of my constituent, Ms. Pham, and in the interest of time, I certainly will be brief given the conversation. And in the interest of full disclosure, I am a lawyer by profession, but I will not be providing any legal advice today. This is simply publicly available information. I think the committee has really summed this up quite succinctly. We have section 34.13 of the official plan that municipalities may accept a cash settlement for 5% of what the official plan says is the total proposal. And then what's also been brought up is section 42 of the Planning Act, which talks about the payment shall be equal to the value of 100%. Well, equal to the value of the land otherwise required to be conveyed. And there was talk about what that interpretation may be. I'm really here to just underscore the significance, which I don't think now is lost on the committee at all. I did a little research myself and an AI scan, and I looked around to know how this can work in practice, and it came back that it can work in practice, that the amount is based on 100% of the value of the portion of land that would otherwise be conveyed, because I wasn't sure what otherwise be conveyed meant. That entire value of that 5% geographic or area portion. Again, I commend these considerations to the committee. I think the committee is already there. I appreciate having spoken with former Councillor Strangway and Councillor Yeo on this, and Director Barry on the margins of council on Tuesday. And I just perhaps, there are options here for this matter. If more information seems to be needed or more resolution, of course, Chair, to be put over a meeting for two, or to remove the cost condition here, as has been put as well, to get this more sorted out, this important issue. If there are changes, changes may be in the works longer term, as Director Barry noted, in terms of moving to a flat rate to perhaps avoid all of this time, energy, and consternation. That's my my presentation here today, to simply address the committee on behalf of my constituent, Ms. Flam.
All right, sir, and we appreciate you taking the time. If you just remain, are there any questions of Mr. Barry? Mr. Strang?
Councillor Perry, you just suggested a deferral, or putting this off. Is there any reason to believe that there might be something coming to council that would have an effect or could help to clarify what we're doing here that would be in the interest of both the city and the applicant?
Not in the short term, in terms of the council docket that I'm aware of, Mr. Strangway.
Okay, thanks.
However, there's also, I've made a suggestion, not a suggestion, rather perhaps an option, is for this committee to put this matter over a meeting or two while there can be talks or further comfort levels obtained. And yeah, I would put that on the radar as well.
Thank you, sir. Follow up, Mr. Emery, or no?
That's an interesting suggestion. I'm just not quite sure how the rest of the committee feels.
Sure.
We'll find out about it.
This is in the committee's hands.
Thanks, Councillor Perry. Really appreciate you coming today.
Thank you.
Thank you, sir. Anything further of Mr.
Chair, I need to be on my way. Am I excused from being here?
Thank you again.
Thanks very much.
All right. All right. Is there anyone else here or online wishing to speak in support of this application, in support of the application? Anyone here or online wishing to speak in opposition to this application, opposition to the application? Being none. Committee, where are we? Ms. Archer, did I see a little? I thought I did.
I would move that it be as printed, as our only three options. I don't agree with the other two. There is the option of having it put over for a couple of months or a couple of meetings, whatever, but it's been going on for 2 years now. So I would move that we, as printed.
And second, oh, okay. Do you wish to speak further to it, Ms. Archer? Councillor Yeo, do you wish to speak to it?
Just briefly, I totally agree that it should be moved forward today, and given the appeal period that will be coming forward, any disagreements with this decision can be appealed, and others beyond our pay grade perhaps can hash out what they're asking this committee to do, which I think we're in a position to do. Thank you.
Thank you, sir. Are there any further comments or questions from committee members? Ms. Richardson, go ahead.
Under the conditions of provisional consent that was attached to our report, there are a number of strikeouts. So I'm presuming that they would not be included in the final draft.
Question to the director?
Yes, please.
Thank you for the question. That's correct. The strikeouts would not apply. There are modifications that have been made to Appendix D that, in our opinion, do pick up the request of the applicant regarding the way that ownership has been identified in previous conditions. So I'm now referring to Condition 5 of Appendix D. The strikeout is leaving the current ownership as Amy Lynn Pham. I believe, Mr. Chair, that Mr. Carroll asked that this just be instead read to be that the ownership be identical without actually naming who is on title today. Staff really don't have an opinion on this. We think that based on what MPAC is telling us today is the ownership, that the way it's drafted in Condition 5 is appropriate. However, we are flexible in this regard, and should the applicant wish that the recommended revised language be incorporated instead of naming the current owner, Amy Lynn Pham, then we would be amenable to that.
Well, the motion is as printed, so I'm going to leave it as such.
So in the provisional consent conditions, number 3 was struck out, so I'm presuming it will not be included, and number 10 was struck out?
I think she's indicated that's the case. The strikeouts were part of the motion, correct?
That's correct.
Anything further from committee? All right, well, as the chair, I get to vote, so I get to say something as well. And I support the motion totally. As indicated in the report, the condition Condition 4 represents a standard the City of Kawartha Lakes applies consistently in accordance with the Planning Act and the official plan. The bottom of page 3 of 26, the report indicates that in some detail that a vetting process was carried on here, and it looks like it was an exhaustive vetting process. And I would suggest exhaustive is probably an understatement, because it looks like all the bases plus the 10th one was covered here. So in my opinion, it's well written. Thank you, Director, and I support the motion. Having said all that, we're going to do a recorded vote. And Ms. Archer, I will start with you.
In favor?
Councillor Yeo.
In favor?
Mr. Finn?
In favor?
Mr. Erickson?
In favor.
Ms. Richardson?
In favor.
Mr. Strangway?
In favor.
And I'm in favor. The motion passes, and your application is approved as printed, ma'am. All right. And having said all that, I think we'll take 5. I do appreciate everyone's patience, but I would reiterate, I guess, that this committee is here not just to make decisions, but we're here to make informed decisions, and sometimes that takes a little while, but we make no apologies for that. But I thank you for your patience, I really do. And moving right along, we're now dealing with file number D20-2025-033, and this is 29 Riverside Drive, Geographic Township of Ops, and Ms. Evans, you are on. Thank you.
Thank you. The property is designated waterfront under the City of Kawartha Lake's official plan and is zoned shoreline residential under the Township of Ops zoning bylaw. It's surrounded by residential and agricultural land located on the western shore of Scugog River. It currently contains a recently constructed single detached dwelling. And just a note, our air photos are from 2023. That's why the dwelling is not on the air photo. The proposal here is to construct a detached garage, which will provide additional storage space for the owner's belongings, including a boat and a trailer. And the intent of constructing the garage in this location is to ensure that a trailer can be backed into the garage without being impeded by the dwelling or the deck that's attached to the back of the dwelling. Several properties in the area have detached garages, so the proposal is in keeping with the existing built form. Relief is required from Section 6.2 of the zoning bylaw, which requires a minimum rear yard setback for accessory structures of 6 meters. As seen on the sketch here, the proposed setback is 1 meter. Also, Section 6.2 requires a minimum interior side yard setback for accessory structures of 2 meters, and the proposed setback is 1 meter. Relief is also needed from, again, Section 6.2, which permits a maximum height for accessory structures of 5 meters, and the proposed height here is 5.2 meters. Looking at now an air photo with the proposed location of the detached garage in the orange circle, and then a photo looking into the neighboring property and the rear yard of the subject property. The proposal does have a reduced rear yard setback. The neighboring property to the west that abuts the rear lot line of this property is approximately 4 hectares in size, and it has a dwelling that is approximately 47 meters away from where the proposed garage would be located. Impacts to massing, privacy issues, and building maintenance are not anticipated with this reduced rear yard setback. Now looking to the interior side yard, the proposed garage will abut the rear yard of the neighboring property to the north and will not abut the neighbor's dwelling, so privacy impacts are not anticipated here. And the proposed 1 meter setback will provide adequate access as well as space for performing any building maintenance. Here we have on the left just a photo of the existing dwelling for some context, and then on the right is a photo of the neighbor's garage, which is the abutting property to the south. So the proposed garage here is going to be located in the rear yard, so it will be minimally visible from the road, and the existing dwelling will remain visually predominant. And it's not anticipated that the additional 0.2 meter height will be perceptible. The proposed garage does not contain a second dwelling, and that additional height is for the desired pitch of the roof. Just for comparative purposes, as seen in the photo on the right here, the neighboring property does contain a 1.5 story garage, so taller garages are not, do exist in this area. No comments of concern were raised by any of the circulated agencies. Comments were received from the owners of the abutting property to the north, to the south, and to the west, and all 3 of these comments were in support of the application and the proposal. Based on the contents of the report, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified within the report. Thank you.
Thank you, Ms. Evans. Questions of the planner? Being none, is the applicant here or online? Yes, sir. Could you state your name for us?
Michael Riddell.
Go ahead, sir.
Thank you, Mr. Chairman. I'm just here to answer any questions.
All right. Are there any questions of the applicant? Looks like your easy day, sir. All right. Thank you for that.
Thank you.
Yeah. All right, is there anyone here online wishing to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application, opposition to the application? All right, being none, committee, Mr. Strangway.
As recommended by staff.
Do I have a seconder? Mr. Finn. Any further comments or questions with respect to the motion on the floor? Being none, Mr. Strangway.
In favor?
Mr. Finn.
In favor?
Mr. Erickson.
In favor?
Ms. Archer.
In favor?
Councillor Yo.
In favor?
Ms. Richardson.
In favor?
And I'm in favor. The motion carries. Your application is approved, sir. Right, we're now dealing with file number D20-2025-034, and this is 433 Beaver Road, Lot A99, Geographic Township, Emily. Mr. Shahid, go ahead, sir.
Thank you, Mr. Chair. The subject property, also known as Park Ridge Beaver Narrows Cottage and RV Resort, is situated along the shore of Pigeon River with access from Beaver Road. The subject property itself is a trailer park or camp that contains multiple trailer lots and camping sites for rent on a seasonal basis. The park is open from May to October and offers seasonal sites to tenants for vacation and recreational purposes. According to the Municipal Property Assessment Corporation, or MPAC, the park contains various styles of trailers, with the most common additions being for a new sunroom and decks. The variance is for trailer lot A99 of the trailer park, which I'll refer to as the site. So this site currently contains a park model seasonal trailer with a sunroom and deck. The proposal seeks to facilitate the recognition of the existing deck and sunroom attached to an existing trailer. The deck contains both a covered and uncovered component, as you'll see in the next slide. So to give some context, the trailer was existing on another site within this park, and the owners moved it to this site and rebuilt their deck slightly bigger than before as it got damaged during the move. And relief is required from various provisions which generally aim to regulate the size and placement of structures associated with tourist trailers within a trailer park to prevent overdevelopment, maintain consistent site layouts, and ensure adequate open space between units. So many trailers in the park have sunrooms and attached decks, reflecting a common pattern within the trailer park. The existing front yard setback exceeds the 3-meter minimum requirement, ensuring access routes remain unobstructed, and the separation between neighboring units is also compliant. Also, the site is well buffered on all sides by vegetation, significantly reducing any visual impact. In terms of comments, there were no comments of concern received from any of our agencies, and no public comments were received either. All in all, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified. Thank you.
Thank you, sir. Other questions of the planner? Being none, is the applicant here or online?
Yeah, I am. I'm
And
here.
your name, please?
Mina Famiati.
All right, go ahead.
I'm only here to answer any questions.
All right. No one's very verbal today. All right, are there any questions of the applicant? Well, again, an easy day for you as well. Thank you for taking the time.
Thank you very much. Bye.
Is there anyone here or online wishing to speak in support of this application? Speak in support of the application. Anyone here or online wishing to speak in opposition to the application? Opposition to the application. Being none, committee, where are we? Ms. Richardson.
As recommended by staff.
All right, do I have a seconder, Mr. Erickson? Any further comments or questions with respect to the motion on the floor? All right, Ms. Richardson.
In favor?
Mr. Erickson?
In favor?
Mr. Finn?
In favor?
Ms. Archer?
In favor?
Mr. Strangway?
In favor?
Councillor Yo?
In favor?
and I am in favor. Your application is approved. Thank you for taking the time. All right, we're now dealing with file number D20-2025-035, and this is 331 Logie Street, former town of Lindsay. Ms. Evans, go ahead.
The property is designated urban settlement area and environmental protection under the City of Kawartha Lake's official plan, and residential and environmental impact study area under the Lindsay secondary plan. It is zoned residential multiple 2, exception 24, under the Town of Lindsay zoning bylaw 2000-75. The property is located at the southeastern edge of the former Town of Lindsay in an area that contains commercial uses, park space, and relatively new residential development constructed approximately between 2015 and 2016, according to Municipal Property Assessment Corporation. The subject property is irregular in shape and has frontage on Logie Street. The development here consists of 45 condominium townhouse units, a private common element street, stormwater management facility, and 15 visitor parking spaces. And those visitor parking spaces would be in addition to the parking spaces that are dedicated to each townhouse unit. So the proposed subdivision was granted draft approval by Council on March 22nd, 2022, and was granted an extension of draft approval on January 2nd, 2025, and the proposal is currently going through the site plan approval process. For our minor variance today, relief is needed from section 5.12G, which requires a minimum aisle width of 7 meters. The proposed width of private road C is 6 meters. And section 10.3.24G, which permits a maximum building height of 10.5 meters. The proposed height is 11.5 meters. So the previous version of the development, and here we're just looking at the elevations of these townhouses. The previous version of the development proposed flat roof townhouses. But there was some concern from the community with that design and how it might fit into the rest of the area. So the design was changed to be sloped roof design. The height and configuration of the other proposed townhouses in this development can be accomplished within the maximum height. It's only the 6 townhouses in what's referred to as Block E of this proposed development that require relief. So in order to, and in an effort to create visual interest through variety, this development contains blocks of townhouses that differ in size, number of units, as well as appearance. And Block E has a bit more of a complex roof design than the other blocks, which results in this increased height. The subject townhouses are to abut the driveway that goes into Logie Park and are separated from other residential uses by Logie Street. The proposed 3-story townhouses are not anticipated to negatively impact the overall character of the area, which currently contains a mixture of 1- and 2-story single detached dwellings and townhouses. So looking now at Private Road C, which is shown in the light blue on the sketch here, the intent of a minimum aisle width is to ensure there's adequate space for vehicles to negotiate the parking area. Private Road C is to function as access to 8 visitor parking spaces. It will be a dead end. It won't be used for the movement of through traffic. The proposed 6-meter aisle width is considered sufficient for the movement of vehicles in and out of these parking spaces. No comments of concern raised by any of the circulated agencies, and no comments were received from members of the public. Based on the contents of the report, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified within the report. Thank you.
Thank you. Questions of the planner? Ms. Archer.
Are you pleased to the planner? Not that it really makes any difference, but just which of the purple globs is it that we're dealing with? The one on the right-hand side, the bigger one? The higher height will be the one at the right-hand side?
Through the chair, so everything that's shown in purple, those are the 6 townhouses. So they're all attached together. So it's a block of 6 connected townhouses that are all seeking relief for the height.
Anything further from committee? Ms. Richardson, go ahead.
Will the narrower, through you, will the narrower or road width have any impact on emergency services vehicles such as fire trucks, et cetera?
Through the chair, that blue block is only to access vehicle or visitor parking. So the actual access to the townhouses will be through this road here with all of their driveways. So if an emergency vehicle was coming to help someone in these townhouses, they would be using this road, which is of the height that's required of the zoning bylaw. This particular road is just to get into these 8 visitor parking spaces.
Anything further from committee? All right, being none. Is the applicant here or online? Yes, your name, please.
Hi. Yes, Madison Van West with KLM Planning Partners. Thank you very much. And through the chair, we would just like to thank staff for their work on the report. And we're here if you have any questions.
All right, well, let's determine that. Are there any questions of the planner? All right, looks like you got off easy again. That's the third one today. All right.
Thank you.
Yeah. All right, is there anyone here online wishing to speak in support of this application? In support of this application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Being none, committee, where are we? Ms. Archer.
It's printed.
Any further comments or questions with respect to the motion on the floor? All right, Ms. Archer.
In favor.
Mr. Erickson.
In favor.
Mr. Finn.
In favor.
Councillor Yeo.
In favor?
Ms. Richardson.
In favor.
Mr. Strangway.
In favor?
And I'm in favor. Your application is approved. I guess she's
Thank
still.
you very much.
All right. Moving right along. We're now dealing with file number D20-2025-036, and this is 35 Peace Road, Geographic Township of Ops. Mr. Shahid, go ahead.
Thank you, Mr. Chair. The subject property is situated near the intersection of Settlers Road and Peace Road in the rural community of Reboro. The area is characterized by low-density residential buildings and agricultural lands. The property currently contains a 2-story single detached dwelling, a detached garage, and a barn. The proposal seeks to facilitate the construction of an addition and new porch onto the existing 2-story dwelling. The addition includes a 2nd story built over the current 1-story section and a new 1-story extension to this side. It must be noted that the existing dwelling is deficient in its front yard setback. The proposed 2nd story addition within the front yard setback does not encroach any further into the minimum setback beyond what exists today. The 1-story extension to the side is approximately 0.3 meters or a foot closer to the front lot line than the existing building. And the proposed front porch is required for access to the dwelling, and there's no clear established building line along Peace Road or in the general community. Moving on to building separation. So the intent of the building separation provision is to ensure safety from fire hazards, prevent overcrowding, and contributes overall to the overall aesthetic of properties. The current setback from the dwelling to the existing garage will remain unchanged at 1.52 meters. And this setback provides adequate space for passageway between the 2 structures. Any required mitigation regarding fire hazards are ensured through the Ontario Building Code, building separation requirements. In terms of comments, no comments of concern were received from any of our agencies, and no public comments were received either. All in all, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified. Thank you.
Thank you, sir. Questions of the planner? All right. Oh, Ms. Richardson, go ahead.
Through you, are there any concerns with respect to the septic?
Mr. Shahid?
Through you, Mr. Chair, this was circulated to septic and they did not detail that they had any concerns.
Okay. Anything further from committee? All right, being none. Is the applicant here or, yes, sir, do you wish to come forward? No, all right. Any questions of the applicant? All right, thank you. Is there anyone here or online wishes to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application. Committee. Ms. Richardson, do I have a seconder? Councillor Yeo, did I see a hand there? All right. Seconded by Councillor Yeo. Any further comments or questions with respect to the motion on the floor? All right. Ms. Richardson.
In favor.
Councillor Yeo.
In favor.
Mr. Strangway.
In favor.
Ms. Archer.
In favor?
Mr. Erickson.
In favor.
Mr. Finn.
In favor.
And I'm in favor. Your application is approved, sir. All right. We're now dealing with file number D20-2025-037. And this is 58 Sugarbush Trail, Geographic Township of Fenland. Mr. Shahid, go ahead, sir.
Thank you, Mr. Chair. The subject property is situated on the shore of Cameron Lake with access from Sugarbush Trail. Sugarbush Trail is a privately maintained dead-end road that provides access to the seasonal residences located at the southern tip of Delhi Point, a narrow peninsula extending into the surrounding water body. The subject property is irregularly shaped, characterized by parallel shoreline lot lines, and contains a portion of Sugarbush Trail running through it. The property currently contains 2 dwellings, a detached garage, shed, and an outdoor swimming pool. One of the dwellings is to be demolished along with an existing shed and pool. The dwelling to remain is 1 story with a basement walkout. The proposal seeks to facilitate the construction of an addition onto that existing 1-story dwelling. So due to the lot's irregular configuration, it is difficult to accommodate both the minimum required water setback and minimum setback from the road. The applicant has proposed a staggered building design that ensures development does not encroach further toward the road while maintaining a compliant water setback. There's no clear established building line along Sugarbush Trail, with dwellings set back at varying distances. The proposed development does not impact the traveled portion of the road. The dwelling being demolished is set back 4.42 meters from the road, and the existing dwelling to remain is also deficient, but to a lesser extent, with a front yard setback of 4.75 meters. The proposed addition maintains that dwelling's existing deficient front yard setback of 4.75 meters. Moving on to comments, there was no comments of concern received from any of our agencies, and no public comments were received either. In conclusion, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified. Thank you.
Thank you. Questions of the planner? Ms. Archer.
Through you, please, to the planner. I think in Appendix C, it was kind of small for my eyes to see, but I believe there is mention of a pool shed. Is it going to remain on the property?
Through you, Mr. Chair, no. So the pool is being removed, that shed and both of those, that shed that says to be demolished, and the shed for the pool is also being removed.
Okay, anything further from committee? Ms. Richardson, go ahead.
Through you, is there a timeline for when these dwellings will be demolished or removed?
Through you, Mr. Chair. So as the condition is read, there is 24 months for the construction of the addition. Now, condition number 1 also reads that this approval shall proceed generally in accordance with the sketch. So the sketch has detailed that the pool has, that these structures are being removed, so they have to remove these structures within 2 years.
All right, anything further from committee? All right, being none, is the applicant here? Yes, sir. Do you wish to come forward? And your name, sir?
My name is Brian Armstrong. To answer,
Do you wish to speak to it?
yes, I do, please,
Go ahead.
but I'll make it quick. Through you, Mr. Chair. You asked about the building, if they would be demolished soon. They will be demolished before we start construction of the addition. There's going to be a new septic system to go in as well. We're going to get rid of the secondary building, the shed that we referred to, where the existing secondary cottage is now is going to be where the new location for the septic is. So it would all be taken care of with right away.
You for that? Any other questions for the applicant? Mr. Strang?
Just a quick one, Mr. Armstrong, lots of room there for a septic system.
Yeah,
I know you've got water on both sides.
Yep, we've done our due diligence and worked through the building department, through the septic division, and have not a permit, of course, but in theory, yes, there's lots of room there.
Thank you very much.
No problem.
Anything further from committee? Thank you, sir. We appreciate you taking the time. All right. Is there anyone here online wishing to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Committee, where are we? Mr. Strangway?
As recommended by staff.
Seconded by Mr. Finn. Any further comments or questions with respect to the motion on the floor? Being none, Mr. Strangway?
In favor?
Mr. Finn?
In favor?
Mr. Erickson?
In favor?
Ms. Archer?
In favor.
Ms. Richardson?
In favor.
Councillor Yo?
In favor.
And I'm in favor. Your application is approved, sir. All right. We're now dealing with file number D20-2025-038, and this is 199 Black School Road, Geographic Township, Mariposa. Ms. Evans.
Thank you. The subject property is designated prime agricultural and environmental protection under the City of Kawartha Lake's official plan and is zoned rural residential type 1 and environmental protection under the Township of Mariposa zoning bylaw. The property is in an area that contains residential and agricultural uses, as well as heavily forested areas. It is irregular in shape and currently contains a single detached dwelling constructed in 2006, a detached garage, 2 sheds, and a truck trailer. And the truck trailer is temporary and is to be removed once the proposed storage building is complete. The proposal being to construct a detached storage building requires relief from section 3.1.3.1b, which permits a maximum lot coverage for accessory structures of 10% of the lot area to a maximum of 150 square meters. The resulting accessory structure lot coverage is 317 square meters, being 2.3% of the lot area. Relief is also needed from section 3.1.3.3, which permits a maximum of 2 accessory structures per lot. The proposed detached storage structure constitutes the 4th accessory structure on the property. Relief is also needed from section 3.1.3.2, which permits a maximum height for accessory structures of 5 meters. The proposed height is 6 meters. So on this slide, we have the sketch and then the 4 proposed and existing accessory structures just on the left-hand side there. So the intent of establishing a maximum lot coverage and a maximum number of accessory structures is to maintain residential character of the property and ensure that residential uses remain subordinate to the primary use, being the residential use in this case. So the proposed storage building is going to be approximately 78 meters from the front lot line. The detached garage is 87 meters from the front lot line, and the existing sheds are approximately 138 meters from the front lot line. As you can see on the air photo here, the property is heavily vegetated, including the front lot line and the interior side lot lines. So if at all, the existing and proposed accessory structures would be minimally visible when viewing the property from the road as well as from neighboring properties. These buildings are also dispersed throughout the property, so nothing appears overbuilt. And while the zoning bylaw does cap or provide a cap for a number of square meters, and this proposal exceeds that, it also provides a maximum percentage lot coverage, which is 10%, and this proposal here constitutes 2.3%. So for just comparative purposes, other rural zoning bylaws use only a maximum percentage to regulate accessory structure lot coverage, which ranges from 8 to 10% of the lot area. This photo shows the area where the proposed storage building is to be located. So it's going to be approximately 60 meters from the closest dwelling on the neighboring property to the east. And as you can see, it is surrounded by mature vegetation. So the additional height is not anticipated to impact neighboring properties. Additionally, while this particular property has residential zoning, the surrounding area is primarily zoned agricultural, where one would typically find taller buildings. So this proposal would not necessarily be out of character with the surrounding area. No comments of concern were raised by any of the circulated agencies, and no comments were received from members of the public. Based on the contents of the report, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified within the report. Thank you.
Thank you, Ms. Evans. Questions of the planner? Ms. Archer?
Not a question per se, but I would like to see a condition put in that the trailer be removed and photographic evidence provided after the fact.
Do you wish to speak to that, Ms. Evans?
Through the chair, we can do that. There is a provision in the zoning bylaw that allows for a temporary storage building to be accessory to construction. That requires it be removed until when the construction is finished, or if it's been abandoned for a period of 60 days. But if you would like that additional condition, we can add that in.
Just get the feeling quite often these things, if it's just left the way it is, it will stay there forever, even though we say it can't. There's nothing to make them tell us that it's been gone, so I would
Through the
appreciate
chair,
it.
sorry, we can add that condition just for your information. They're very motivated to get rid of the truck trailer, very motivated. So once this building is constructed, it's gone.
I can understand the applicant's wife probably would be happy, but the applicant usually likes them there.
Hang on to that thought, Ms. Archer. All right. Are there any further questions of the planner? Councillor Yeo, did I see your hand? No?
No.
All right, thank you. All right, is the applicant here or online? Does the applicant wish to speak to the application? Nothing online and no one here. All right. Committee. Oh, I better not first. Is there anyone here online wishing to speak in support of this application? In support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Being none, committee, where are we? Councillor Yeo, as printed. All right, do I have a seconder? Mr. Erickson. Any further comments or questions? Yes, Ms. Archer.
Could I ask that the condition be put in about the photographic evidence being?
Councillor Yeo, if you'd accept that as a friendly.
As amended.
All right, Mr. Erickson? All right, good stuff. So it'll be the motion as amended then? Everyone clear on that? All right, good. Any further comments or questions with respect to the motion on the floor? Councillor Yeo?
In favor.
Ms. Archer?
In favor.
Mr. Erickson? Oh, I guess you were the second, right? Mr. Finn?
In favor.
Mr. Richardson? Ms. Richardson, I'll be all right.
In favor.
Been a long day. Mr. Strangway?
In favor.
And I'm in favor. Well, wherever you are, applicant, your application is approved. Moving right along, we're now dealing with file number D20-2025-039, and this is 51 Trinity Drive, Geographic Township of Verlem. Oh, Mr. Oakwood. My gosh. Right, this is a tough committee, so you be careful, okay?
Thank you, Mr. Chair. The subject property is located along the shoreline of Sturgeon Lake with access from Trinity Drive. The lot is currently developed with a single-story detached dwelling, a boathouse, a detached garage, and a shed. All structures, with the exception of the shed, were constructed in 1950. The proposal seeks to permit the construction of a second-story addition to the existing dwelling. Relief is requested from the water setback and rear yard setback. As redevelopment occurs over time, it is both reasonable and expected that property owners will seek to modernize and improve existing structures to enhance the quality and functionality of their properties. The subject property is zoned limited service residential zone under the Township of Verlem zoning bylaw, which permits a single detached dwelling. The zoning bylaw requires a 7.5 meter rear yard setback and a 15 meter water setback. The proposed rear yard setback is 2.14 meters from the deck and 4.31 meters from the dwelling. The water setback remains 3.56 meters from the deck and 6.31 meters from the dwelling. These setbacks are consistent with the existing dwelling and deck, which were built before the zoning bylaw was adopted. The proposal maintains the existing encroachments of the single-story dwelling with no anticipated negative impacts from the addition of a second story. Comments were received after the writing of the report from Kawartha Regional Conservation Authority, indicating that they have no concerns and that they require a permit. And staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified. Thank you.
Thank you, sir. Are there questions of the planner? Ms. Archer, I told you to be tough.
What's the difference, please? Explain to me the difference between a rear yard setback and a water setback.
Yes, through the chair. A rear yard setback would just mean from the lot line, and the water setback would be from any water body. So, for example, if this property wasn't on a shoreline and it would be some way further back, that water setback would still apply. But the rear yard setback is just to the rear lot line.
This one, they're the same line?
It's the same line for this one, essentially.
Further questions of the planner? All right. Is the applicant here?
I am.
Could you, all right, it looks like it's already on. Your name, sir?
William Scott.
Do you wish to speak to it?
No, I'm here just to answer any questions the committee may have.
All right. Are there any questions? Yes, Mr. Strangway.
Mr. Scott, thanks for coming. Just wondering about septic. As you're adding square footage, is there a concern, or is that something that you've dealt with?
Yeah, I dealt with it about 5 or 10 years ago. 10 years ago, we put in a brand new septic on the other side of the road. So it's been modernized and it's very large.
Perfect. Thank you very much, Mr. Scott.
Are there any other questions of the applicant? No, thank you, sir. We appreciate that. All right. Is there anyone here online wishing to speak in support of this application? In support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Being none, committee, where are we? Mr. Finn.
As recommended.
Second by Mr. Erickson. Any further comments or questions with respect to the motion on the floor? Being none, Mr. Finn.
In favor.
Mr. Erickson?
In favor.
Ms. Archer?
In favor.
Councillor Yeo?
In favor.
Mr. Richardson?
In favor.
Mr. Strangway?
In favor.
And I'm in favor. Your application is approved, sir. Well, we're moving so quickly here I can hardly keep up. All right. We're now dealing with file number D20-2025-040, and this is 220 Washburn Island Road, Geographic Township of Mariposa. And again, Mr. Okowit.
Thank you, Mr. Chair. The subject property is situated on the shoreline of Lake Scugog with access from Washburn Island Road. The property is within an established residential neighborhood and currently contains a single-story dwelling and a detached garage, which were both constructed in 2003. The proposal is to permit the construction of an attached deck, and relief is requested from the water setback. The subject property is zoned rural residential type 3 under the Township of Mariposa zoning bylaw. This zone permits a single detached dwelling as well as accessory structures. Under the Township of Mariposa, a minimum water setback of 30 meters is required. The proposal is requesting an 18.8 meter setback from the water, creating a deficiency of 11.2 meters. The intent of the water setback is to protect built form from natural hazards and protect and enhance the ecological function of water bodies by creating a buffer between built form and water for the establishment of vegetation. Although the proposed setback of 18.8 meters does not meet the zoning bylaw's minimum requirement, it maintains a substantial buffer that supports the intent of protecting the shoreline's ecological function. Comments were received after the writing of the report from the Kawartha Region Conservation Authority, indicating that there is an active violation on the property for the proposed deck. Kawartha Conservation will support the minor variance, provided that the violation on the property is resolved by the owner in coordination with the Kawartha Conservation before July 15th, 2025. Condition number 3 has been added to this application for the applicant to resolve this violation prior to obtaining a building permit. Comments were also received from a member of the public. The property owners at 228 Washburn Island Road expressed concerns regarding the size of the proposed deck and whether the property has obtained a license to operate as a short-term rental. I have provided information regarding the size of the deck. Any concerns of short-term rental licensing falls outside of the scope of this minor variance application and should be directed to municipal law enforcement for further review. Staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified. Thank you.
Thank you, sir. Questions of the planner? Mr. Finn?
Just for my own information, any suggestion as to why this is necessary? They seem to have a deck already around the existing pool with the steps going down towards the water.
Mr. Hogarth, go ahead.
Through the chair. So the existing patio area is mostly landscaped. It's not above ground, so it wouldn't meet the definition for an accessory deck. The proposed deck over here would, just because it is raised from the ground.
Thank you.
Ms. Archer.
Through you, please, to the planner. On page 3, I may be reading it wrong, but on the bottom, at the bottom paragraph, the current water setback is 18.8. The proposed is 11.2. Is it really 11.2?
Through the chair, my apologies for that. So the report will say that, but the setback is 18.8 meters and the deficiency is 11.2 meters.
Anything further from committee? All right, being none, is the applicant here? Yes, sir. Do you wish to come forward? I'm the applicant right now, so I'll ask you to wait until I call for yourself. All right. Is the applicant here or online?
Yes, Joe Dome.
All right. I don't see your picture, sir, but we can hear you, so go ahead.
Yes, I'd just like to add a few comments. Fairly straightforward application for the rear deck extension. The one variance proposed, as mentioned, for the water setback, 18.8 meters. But I'd like to just point out this variance pertains mainly to the north side of the rear of the property, which is angled, and the water setback to the existing pool deck widens further to the south. And the width of that deck that is shown there in the photos is 4.36 meters wide. the application does comply with all other bylaws and does maintain a reasonable setback to the water. Planning staff have noted that the proposal is consistent with surrounding properties, many of which also feature decks encroaching within the water setback. And we do agree with planning and conservation recommendations.
All right, thank you, sir, for that. Are there any questions of the applicant? All right, doesn't appear to be any questions, sir. Thank you for that. All right, is there anyone here or online wishing to speak in support of this application? In support of the application? Anyone here online wishing to speak in opposition to the application? Opposition, yes, please come forward, sir. Turn that mic on. There's a button there that says speak, I
Oh, there
believe.
you go.
Yeah.
Oh, there.
And your name?
My name is David Parenter. I live right beside this 220. I'm in 224 Washburn Island. And it's, I don't understand why they would want to build a bigger deck onto the lakeside, because I just built my house last year, and I had a whole bunch of problems because of being by the lake. When I backfilled, they couldn't go too close to the lake because they had to be fairly close. But I understand that they are going to be closer than 18 or something, you said, with this deck. And the problem I have is I put a fence along my property line because I just built the house last year. I got it built. And it's an Airbnb. So every weekend I have to deal with new people from whoever owns this place, because I don't know. I had never seen them, because I see every week or weekend, especially in the summertime, new people coming into the place. And that's why I built the fence. I didn't build it. I got somebody to build a link fence. But if the volleyball or something from them, they jump the fence instead of walking around. They jump my fence, and I've yelled at them, and I've complained. I've called the police on people that are there, because not necessarily loud music or anything like that, because they do have kids, but just jumping the fence, no respect on my personal issue. And then with this deck coming, if they get permission, it's just that means that they got another spot to sit and do whatever they do outside. But it's very irritating, because my wife passed away a few years, and this was our dream home, and I didn't dream of this being next door to me. Now, it's very tough on my life situation, and it's very tough that I can't figure out why they would do this, because apparently I've called to the ministry, and then they gave me the number to complain to the Airbnb, and apparently it's not even registered as an Airbnb, from what I've been told. But there's people coming in and out, not necessarily now or in the wintertime, but in the summertime when it's nice to go outside. And personally, I don't, even my daughter, 25, she was yelling at the people, because they come, and then the volleyball comes over, and instead of walking around, they just jump the fence, because they don't care. So I don't propose how a deck is going to make a big difference. And I personally think that they will build it closer to the water, because of what I understand from them anyways, from the feeling I get. I've only just moved in a year ago, and this was not part of my dream to go through this. And I have to deal with it every weekend in the summertime, because there's people coming in and out all the time, like I said. And I had pictures on my phone, not on my phone anymore, it seems that, but there's like 14 cars in the driveway. So you figure 2 people per car, and they advertise it that it sleeps 14 people. So where's the septic? They've never done anything to the septic, because when I built last year, they went by how many washrooms are in the house that I was built, that I didn't build, but anyways, and they accordingly put a certain amount of people that would live by the bedrooms and the washrooms. And now, how can they advertise it? Because it is advertised. I looked that up, and my daughter did, and it says sleeps 14. How can you have, because when I built my house, they were pretty specific for the septic field. And this is an older house, and how can they accept, like, because there's kids, there's everything, flushing the toilet, whatever. Okay, go ahead, sorry.
Yeah, well, I would advise you that as part of our mandate here, we can't deal with your neighbor problem, so.
No, I know, I
and you
understand.
have called the police.
Yes.
As far as, I'll ask Mr. Okawat to respond to your question regarding the septic, or Mr. McKinnon. You have any response to that, Mr. Okawat?
To the chair, Septic did reach out and they provided no concerns.
So we've had, let's call it, our professional people look at the septic situation and they don't have any concerns with it. So obviously, apparently it's adequate to deal with the situation there as far as the room's concerned. But we can't deal with your concerns that you've mentioned there, unfortunately, so.
Well, it's just, my concern is building the deck, and I believe it'll be the whatever you want to call it, down by the lake. I believe it'll be closer than 18-something meters away.
Well, something that would have to be dealt with at the time. If, in fact, they were encroaching upon that distance, then we would hope that it would be caught, or I'm sure if you see something, you'll report it.
Oh, absolutely, you're right.
Right, so we can leave it at that until such time as there actually is an infraction.
It's just that I wanted to do something because, again, my wife passed away, but the point is she would do her best to diligently to avoid conflict with these people because, again, it's an Airbnb, so every weekend I have to deal with new people coming in, climbing the fence, which I put up so that they don't do it, and I just don't understand how they can get a permit for another deck, which is already a big deck and everything. You can see the pool and their deck around the pool, and then they have a hot tub, and then they want to build a bigger deck.
Well, you've heard that from the planner that the deck that they are applying for meets the requirements, the 4 tests of we call planning. So unless there's an infraction that occurs as a result of that deck being built, then it is what it is. So it'll go in.
So I have no, the deck will be going forward.
No, you've done what you can. We've recorded your comments, so we have that on file. And I would suggest to you that if you have any further comments regarding the deck situation, then you can call our planners and talk to them.
Okay.
But as far as infractions are concerned, that would be the building department or police if you're talking about people infractions. So
yeah, 'cause
we'll have to leave it at that.
Anyways, yeah, so it's just very, sorry, it's tough on me. It's, okay, I'm
No.
sorry.
Yeah, obviously, waiting, but now are there any questions of the applicant? Ms. Richards?
Not of the applicant, but perhaps to the planner. Or
Didn't say the applicant. Go ahead.
I was just going to ask, I believe the city has got new legislation with respect to Airbnbs. So if that's his concern, could he not discuss that with the planning department or some other department at another time other than this?
Well, that's what I've asked, if he can do.
Yes.
Do you, Mr. Okawat?
Through the chair, yes, exactly. Well, I thank the member of the public for attending here and voicing their concerns. Concerns are very valid, but Committee of Adjustment would not be the arena to voice these concerns, as this would be more fall in line into a municipal law enforcement matter, as I indicated prior. I would be happy to connect the member of the public with them and talk about that issue, but as it stands, the minor variance is just for the water setback, and that's what the focus should be on.
And that's where we are, sir. As I suggested to you, please feel free to call the planning department if you feel they can assist you in any way.
And with the, because I complained to the ministry last year, and they've given me this phone number to compile, because it's not registered. I called this number that the ministry of Kawartha Lakes gave me to complain, and they told me that this place is not registered as Airbnb or whatever other term you want to call it. But yes, it just, they said it's not a registered place. So I'm having a hard time. And then they build this deck, and then in order to get more people in, because they'll be able to have more people. And personally, 14 people at one house, does that not make, like, over a weekend? That just tells me that's a lot of people.
You know, we hear your frustrations and we hear your concerns, and we take them seriously, believe me. We've recorded. So I would suggest that to you that there may be further avenues you can explore, be it with our planning department, with our bylaw, or with the police with respect to your other concerns, okay?
Yes, well, yes, I have called the police, but they came and they said, well, I can give them a trespassing ticket, but it's only $54. And these people are like Brampton, Toronto, wherever they come to rent the place, they're never going to pay that's what the police officer told me, that they'll never pay the fine. I said, well, okay, just.
All right, well, thank you for your time, and we appreciate you coming. Thank you.
Thank you.
Is there anyone else that wishes to speak in opposition to the application? In opposition to the application? Being none. Committee, where are we? Committee, where? Mr. Erickson.
Back to the question of the planner. What's the difference between this application for a variance to the setback versus structures that are permitted in the water setback?
Through the chair, could you please rephrase the question for me?
Maybe a little more clarification would be required.
What's the difference between this application versus structures that are permitted in the water setback without having to, like gazebos and so forth?
Through the chair, accessory structures would all have to follow the water setback. The only structure that comes to my mind that would be permitted would be a boathouse. So the attached deck right now would be subject to the water setback.
Follow
up? There's more than just boathouses permitted in the water setback. That's why I'm asking.
Through the chair, could you please identify which structures come to mind?
Now, this deck, the application is the proposal for the setback in the water setback, but there are structures that are permitted in the water setback that don't need any applications for variance for setbacks, such as boathouses, kiosks, gazebos. I'm just wondering what's the difference here?
Maybe they previously exist, or they're non-conforming. I don't know where.
Through the chair, yes, exactly. If it previously existed, those aren't what we would be looking at. Right now, we're looking at a new structure that's being developed with the current zoning bylaw that's in effect. And in this case, the attached deck encroaches within the water setback, so it would require a variance. As far as boathouses are concerned, they would have some leeway when it comes to water setbacks. Gazebos would not. And I'm not sure about kiosks, but if you provide me a moment, I can definitely take a look or connect later.
I think that's probably as close as we're going to get, so we'll let that be. All right. Anything further? Do I have a motion? Ms. Richardson.
I'm recommending the updated conditions that were provided to us.
All right. Yes. Do I have a seconder? Mr. Finn.
Second.
Any further comments or questions with respect to the amended motion? Being none, Ms. Richardson.
In favor.
Mr. Finn?
In favor.
Mr. Erickson?
In favor.
Okay. Ms. Archer?
In favor.
Councillor Yeo?
In favor.
All right. Mr. Strangway?
In favor.
And I'm in favor. The application is approved.
Thank you very much.
I guess I should have asked, well, we're now dealing with file number D20-2025-042 and D03-2025-019, and this is 3 Birdie Street, former town of Lindsay. Mr. Shahid.
Thank you, Mr. Chair. The subject property is located in a well-established residential community near the intersection of St. Patrick Street and Birdie Street. Based on data from the Municipal Property Assessment Corporation, the area is largely comprised of residential buildings in the form of single detached dwellings. There's a public park directly to the south, Kinsman Park, and there's an elementary school further to the west. So the property currently contains a single detached dwelling that was constructed in the year 1880. The proposal seeks to create one new residential building lot and retain a lot containing the existing dwelling. The minor variance is being processed concurrently with the consent application, and through the minor variance, relief is being sought to adjust the proposed reduced lot frontage of the lot to be severed. So the retained lot requires a larger frontage in order to ensure the existing dwelling continues to comply with the minimum interior side yard setback from the proposed lot line. The proposed severed lot provides an adequate building envelope to accommodate yard requirements and also complies with the maximum lot coverage. The surrounding lot fabric consists of rectangular lots with varying areas and frontages. So in the immediate context, I looked at within 100 meters of the subject property. Frontages of lots with existing single detached dwellings range from approximately 9.45 meters to 21.32 meters. Moving on to comments, a letter of opposition was received from the owners of 8 Birdie Street. This letter was provided to our committee members alongside the staff reports last week. So to address some of these concerns, first of all, I just want to say thank you to the public member for sending in this letter. The proposed consent does indeed increase density, which aligns with both provincial objectives and local policies. And this is also explained in the staff report. With this consent, the owners are required to provide cash in lieu of parkland to the city. So this requirement allows the city to collect funds which are used to improve existing recreational infrastructure and parks, which as a result is an improvement in this aspect. No other comments were received. To conclude, staff acknowledges proposed consent represents good planning and that the minor variance meets all 4 tests of a minor variance, and we recommend approval of the applications. Thank you.
Thank you, sir. Yes, Mr. Strangway, go ahead.
Thank you, Mr. Chairman. And just a quick question. I'm looking back to the very first application, which we spent a long time, and says in number 4, equal to 5% of the appraised value of the retained parcel. Then I look at this application and says equal to 5% appraised value of the land to be severed. The first one was the retained parcel. So why would one be the retained parcel and one be the severed parcel?
Through you, Mr. Chair, it's because the cash in lieu affects the lot that is going to be developed. So in this case, it is the severed lot that is vacant or is going to be vacant. It's the lot that's going to be developed. In the previous case, Leah's application, it was the retained lot that would be vacant and would be developed.
Okay, thank you.
Anything further from committee? Yes, Ms. Richards.
Through you, what is the purpose of the 2.5 meter road widening dedication?
Through you, Mr. Chair, sorry, you said what is the purpose?
Yes, because that would be the only lot that would be dedicated to the city, and there's no other area that I see that the city would require that. If they did, they'd have to expropriate, and I really don't see where they're ever going to widen that road anyway.
Through you, Mr. Chair. So this was something that was requested by the Development Engineering Division, and they have their policies where they look at the width of the road and how much it's actually supposed to be, and they have the ability to request these road widenings. Now, it makes things more streamlined if we request a road widening now and the applicant agrees with it, rather than in the future if they were to, if they would want to expand servicing there or bring the road into compliance with their plans, and they would have to expropriate. So it makes it more simpler now to just do the road widening for the city. And it's typical with all of our consent applications.
Follow-up? No?
I do understand that, but I do know that that is just one little street that I can't imagine they'll ever spend 1 cent on.
Anything further from committee? I have, Mr. Shahid, I've got a question on page 5 of 7. Under the ECA Development Engineering, you've got, where are we here? They're to ensure that existing services to the retained parcel are solely within the proposed retained lands. How are we going to ensure that, I don't see anything that covers that. How are we going to ensure that that occurs?
Thank you, Mr. Chair, for that question. So yeah, this was actually addressed. You should have a revised conditions package. So this is addressed in the revised condition package, and I believe it's condition number 4. Yeah, it's condition number 4.
Anything further from committee? Yes, Ms.
So in the, through you, the person who objected stated that the current house is an apartment. So my question is it a legal or an illegal apartment?
Mr. Rashid?
Through you, Mr. Chair, so the R2 zone strictly permits a single detached dwelling, and then there's some accessory uses, like for example, it says a home occupation. I can't speak to the legality of the apartment dwelling. It could be something that predates the zoning bylaw, but again, we're not here for enforcement. We're looking solely at the severed lot and the requested relief in frontage for the severed lot.
Okay. Anything further? Yeah.
Question, just information. If you go further down the street, there is a multi-residential unit that does exist, and it is legal.
Is that a question? No. Okay. Anything further from committee? All right. Being none. Is the applicant here? Does the applicant wish to speak to? Oh, very good. And your name, please.
Vanessa Arger from TD Consulting.
All right.
On behalf of the owners. Thank you to the planner for his report. And I'm really just here if there's any additional questions for me today.
Are there any questions of the deputy? Everyone got off pretty easily today. All right. Thank you for that. Is there anyone here online wishing to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application. Now, before I go to the committee, Mr. Sheed, perhaps you can answer this. We're dealing with 2 separate file numbers here. Do you want us to deal, and I'm just asking, we can deal with it as 2 separate motions or as one motion? Which are you comfortable with? The director, or somebody?
Through you, to you, Mr. Chair. The director says 2, so we'll go with 2.
Hey, I saw the director raise her hand there. Did you want to speak to it, Director?
Thanks for the opportunity. No, I think 2 just keeps things succinct, concise, clean, and very clear on which aspects of the decision are for which applications. That's all.
That's where I as well. I'm looking for a bear with me here, for a motion on file number D20-2025-042. That'll be the minor variance. Do I have a motion on that? Mr. Strangway? As printed? All right.
Printed.
Do I have a seconder? Do I have a seconder? Mr. Finn? Any further comments or questions with respect to the file number on the minor variance? All right. Mr. Strangway?
In favor?
Mr. Finn?
In favor.
Mr. Erickson?
In favor?
Ms. Archer?
In favor.
Councillor Yeo?
In favor.
Ms. Richardson?
In favor.
And I'm in favor. The application is approved. All right, and now we're dealing with file number D03-2025-019, and this has to do with the severance. So do I have a motion on that? Ms. Archer? Okay, and seconded by Councillor Yeo. All right. Any further comments or questions with respect to the motion on the floor? Ms. Archer?
Favor.
Councillor Yeo?
In favor.
Mr. Richardson?
In favor.
Mr. Strangway?
In favor.
Mr. Finn?
In favor.
Mr. Erickson?
In favor?
And I'm in favor, so they're both approved. Thank you. (20-2025-043), and this is 55 Coldstream Road, Geographic Township of Finland. Ms. Evans, you're back.
Thank you. The subject property is designated rural and environmental protection under the City of Kawartha Lake's official plan and is zoned tourist commercial exception 1, and environmental protection zone under the Township of Finland zoning bylaw. The property is located in an area that contains commercial, residential, and community facility uses. Rosedale Marina operates on the subject property and is one of several marinas in the immediate vicinity. The property owners own the subject property as well as 52 Coldstream, which is located on the water across the road from 55. Both properties are used for the marina and boat storage operation. 55 Coldstream, being the subject property here, contains several storage buildings constructed between 1970 and 1987. The proposal is to demolish one of those storage buildings and construct a new storage building in the same location. The new building will have a very similar footprint to what exists today and will continue to be used for indoor boat storage. The existing building is in relatively poor condition, and the new building will provide improved storage space. Relief is needed from section 18.2.1.3a, which requires a minimum front yard setback of 25 meters. The proposed setback is 9.9 meters. Also section 18.2.1.3c, which requires a minimum exterior side yard setback of 7.5 meters. The proposed setback is 2 meters. The desire here is to use as much of the existing footprint as possible. If the new building was relocated to comply with the minimum setbacks, other storage buildings on the property would have to be demolished, and due to the amount of outdoor storage space required and the location of the environmental protection zone on this property, it would be difficult to replace those storage structures elsewhere on the property. So the goal here is to rebuild where the building currently is. This photo here shows the existing setback, and the proposed setback is outlined with that yellow line. So that bump out that exists on the existing building won't be reconstructed that way, and the building will be flush with that yellow line. So we're actually improving the front yard setback here beyond, or improving it compared to what exists today. The area contains a variety of uses and a variety of front yard setbacks, so there's really no specific distance from the front lot line that defines the character of this area. There's also a approximately 6 meter wide grass boulevard between the front lot line and the traveled portion of the road, which provides a physical buffer between the proposed building and traffic. These photos show the end of the existing building, and then what's the exterior side yard here. So the subject property abuts an unimproved and unopened road allowance called Pine Street. Pine Street is not traveled. As such, impacts to traffic, road maintenance, and sightlines would not occur. However, just based on the definition of what an exterior side yard is and what a street is, this is considered an exterior lot line, and as such, the exterior side lot line minimum setback is required. The Public Works Roads Division, as well as the Engineering and Corporate Assets Division, both confirmed that there are no city planned or forecasted capital projects for the design and construction of a new municipal road within this unopened road allowance. When viewing the property from the road, it's really not perceptible that there is a road allowance here, as it's very heavily vegetated, as you can see in these photos. So it really does function more as an interior side lot line than an exterior. The existing setback today is 2 meters, and the proposal maintains what exists today. So it's not anticipated that there will be any adverse impacts. In terms of comments, the supervisor of plans review and inspections provided that there may be issues with spatial separation, but that will be dealt with at the building permit stage. And no other comments of concern were raised by any of the circulated agencies. No comments were received from members of the public. So based on the content of the report, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified within the report. Thank you.
Thank you, Ms. Evans. Questions of the planner? Being none, we're going to have TD Consulting coming back. For the record, would you give us your name again, please?
Vanessa Archer from TD Consulting, the applicant on behalf of the owners of the marina. Again, just here if there's any additional questions or concerns from the committee members.
Are there any questions of the deputy? Thank you very much.
Thank you.
All right. Is there anyone here or online wishing to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Being none, committee, where are we? Mr. Finn?
As recommended by staff.
Do I have a seconder? Councillor Yeo? Any further comments or questions with respect to the motion on the floor? Mr. Finn?
In favor.
Councillor Yeo?
In favor.
Mr. Erickson?
In favor.
Ms. Archer?
In favor.
Ms. Richardson?
In favor.
And Mr. Strangway?
In favor.
And I'm in favor. Your application is approved. Thank you. Dealing with file number D20-2025-044, and this is 181 Louisa Street, Geographic Township of Fenelon, and just to bring to the committee's attention that we do have an amended motion there. So, all right, who have I got? Ms. Evans.
The property is designated waterfront under the City of Kawartha Lakes official plan and is zoned rural residential type 3 under the Township of Fenelon zoning bylaw. The property is located in an established residential neighborhood on the eastern shore of Cameron Lake. This property has frontage on Louisa Street and its rear lot line abuts the Victoria Rail Trail. It currently contains a single detached dwelling with an attached deck, which are both currently under construction. The proposal is to recognize the dwelling that is under construction. So the plans that were approved through the building permit process complied with the provisions of the zoning bylaw. During the construction process, a type of brick was selected, and that type of brick required a thicker foundation in order to support it, which extended the thickness of the wall, which made it so the dwelling encroaches very minimally into the front yard setback. Unfortunately, the zoning bylaw does not contain a provision that allows for even very minor deviations from the minimum setback. As such, the owners have applied for and are going through this minor variance process to rectify the matter by seeking relief from section 13.2.1.3a, which requires a minimum front yard setback of 7.5 meters. The proposed setback is 7.3 meters. The photo on the left here shows the dwelling that's under construction, and the photo on the right just shows the dwelling and its separation from the road allowance. The dwelling encroaching 0.2 meters into the front yard setback is not anticipated to impact the function of the roadway, and it's not anticipated that it would be perceptible when viewing the property from the street. So speaking of the amended conditions here, after the writing of the report, Kawartha Region Conservation Authority confirmed that a Section 59 drinking water source water protection restricted land notice is required for this minor variance, as the property is within a source water protection area. So when a property is within a source water protection area, all Planning Act applications and all building permits must have a Section 59 notice issued by the risk management official, so the proposal can be reviewed to ensure it does not pose a threat to drinking water. So a Section 59 notice was issued for the building permit. However, because now we're going through a Planning Act application, KRCA has identified that they need a second Section 59 notice. So to make sure that happens, I've included the third condition. No other comments were received from no other comments of concern, rather, were received from any of the circulated agencies, and no comments were received from members of the public. Based on the contents of the report, staff acknowledges the application meets all 4 tests of a minor variance and respectfully recommends approval of the application subject to the conditions identified within the report and the condition added at today's meeting. Thank you.
Thank you. Yes, Mr. Strangway, go ahead.
Thanks, Ms. Evans. Just a question about this Section 59 notice. What's involved in that? Do the owners have to apply for it? Is there a cost to it?
Through the chair, they would just need to get in touch with KRCA. It's a free process. It's really just a letter that KRCA will issue to them to say that they've reviewed what they're proposing and it doesn't pose a threat to drinking water. So there's no cost to them.
It's just a straightforward application, not time consuming, or it doesn't hold anything up.
Through the chair, they do have a very quick turnaround here, and especially because we know that they already got a Section 59 notice for this building. I'm not anticipating any issue getting it for the Planning Act application associated with this building.
I really appreciate your comments about it's unfortunate. I don't know how the rest of the committee feels. Maybe I shouldn't express my feeling about this being here for the sake of, 2 inches because they added brick on the front. But hopefully somewhere in the future, we can give our staff some sort of autonomy to say, hey, look, we understand. I'm discouraged by what we're putting people through for this. This is not what I see as practical. But that's my own opinion. Thank you.
Yeah, through the chair, I'd just like to say I don't feel good about this either. I wish that we could have had some leeway here to make it so the minor variance wasn't required. The only thing that I was really able to do was put this on an earlier agenda than what it would have been. We added this one just to help them out. In the rural zoning bylaw, the new rural zoning bylaw, there is a buffer for errors that can happen during construction. So hopefully that in the future will help with some of these just small variances that happen as a result of the construction process.
That'd be wonderful if that could happen. Thank you.
Yeah, well said, Mr. Strangway. Yeah, thank you. Any further comments or questions of the planner? All right, is the applicant here? Oh, they are, oh my gosh. Do you wish to come forward? Thank you again for your patience. Sometimes it's a long day, so. Hey, could one of you or both of you state your names?
I'm Terry Atchison.
I'm Mike Trues. All right, go ahead.
First, we'd like to say thank you so much to the committee and to the planning department. We've had bumps along the road, but we've also been given every support possible. And all too often you hear complaints. We're just very grateful for what you do and for hearing our case. Okay. That being said, Catherine emailed us this morning. We've already been in touch with the Source Water Committee. We know what to do. It's not painful. they've got our file, they'll turn it around within a couple of days. Okay? So,
Thank you.
thank you. That's all.
But thank you for that, and we appreciate your comments with regard to our staff, because we believe they do an excellent job, and it's nice to hear it from folks outside. So are there any questions of the applicant? All right, thank you very much for taking the time. Is there anyone here online wishing to speak in support of this application, in support of the application? Anyone here online wishing to speak in opposition to the application? Opposition to the application? Committee. Ms. Archer, as amended? All right. Do I have a seconder? Mr. Strangway? All right. Any further comments or questions with respect to the motion on the floor? Being none, Ms. Archer? Mr. Strangway?
In favor.
Mr. Richardson?
In favor.
Councillor Yo?
In favor.
Thank you. Mr. Erickson?
In favor.
Mr. Finn?
In favor.
And I am in favor. Your application is approved. Thank you. All right. We are now dealing with file number D20-2025-045, and this is 1413 County Road 121, Geographic Township of Earlham. Mr. Shahid, go ahead, sir.
Thank you, Mr. Chair. The subject property is situated in the former township of Verulam in a residential agricultural area with access from County Road 121. Although there's no directly abutting structures to the property, the surrounding area is characterized by single detached dwellings and structures typically associated with agricultural uses. So the subject property currently contains a single detached dwelling and a detached garage. The proposal seeks to facilitate the construction of an addition onto the existing detached garage. The owner has indicated that the addition is to be used for the parking of various vehicles, as well as storage of personal items. So relief is required from the side yard and the existing location of the structure. Discussion was held with the applicant regarding the potential relocation of the addition away from the side lot line. So the owner indicated that it is of their personal desire to maintain the proposal and that moving the addition would be a more intensive process as it would require grade alteration and a reduction in green open space. Regardless of the location of the addition, relief would have been required due to the existing non-compliant location of the garage. The potential locations for the addition are limited as it is dependent on the existing location of the garage, which again is non-compliant. But nonetheless, the structure and its use has been established since 1979 and is not anticipated to alter the character of the area. The garage is not visible from the road as it is screened, and it is buffered by vegetation spanning across the front lot line, as you can see from the image in the top left corner on the slide. And the proposed addition does not encroach further into the front yard and maintains a compliant setback from the lot line, from the front lot line, which is approximately 32 meters. Then when we're looking at the side yard setback relief, the Township of Verulam zoning bylaw, which is applicable here, differs from other zoning bylaws as it prescribes setbacks that only apply to properties within a residential zone. In comparison, many of the city's other rural zoning bylaws contain specific setbacks for structures that are accessory to a residential use or building. For example, under the Township of Fenelon zoning bylaw, the prescribed side yard setback for a garage accessory to a residential use is 1.2 meters. In this case, any accessory structure within the A1 zone of the subject zoning bylaw must comply with the side yard setback prescribed for all buildings and structures. The existing garage is not adjacent to any neighboring structure and is buffered by vegetation along the northern interior side lot line. After the writing of the report, comments were received from the Kawartha Region Conservation Authority stating they are not in support of the application. Their reasoning is that the existing structure is within the Burnt River floodplain and that the existing structure exceeds their maximum size permission. Their concerns pertained to flood proofing and loss of flood storage. I should note though that the KRCA short form for Kawartha Region Conservation Authority, does not regulate this area. They only have the ability to provide comments here on Planning Act applications, and that a permit is not required from them. To address their floodproofing concerns, this structure will have to be floodproofed as per the Ontario Building Code, and I've confirmed this with the Supervisor of Plans Review. Additionally, when going over alternative options for the proposal, there were no viable options in benefit of maintaining flood storage. The area has been cleared, as you can see in the images and the aerial imagery, for quite some time, and detaching the structure would require it to be located in the rear yard. The reason being is because in the front yard towards the house, that's where the septic is. So putting the structure in the rear yard would require site alteration, expansion of that gravel area. You would have to bring in fill, all of which would remove existing flood storage. As a result, I believe the existing proposal is the most appropriate option, given there are no other viable options to maintain flood storage. And there were no other comments received. To conclude, staff acknowledges the proposed application meets all 4 tests of a minor variance, and we recommend approval of the application. Thank you.
Questions of the planner? Yes, Ms. Archer?
For you to the planner. So you suggest that we approve it without the KRCA?
Through you, Mr. Chair. Yes, in this case, a KRCA permit is not required. It's just a building permit that they would need, so they're just here to provide comments. And after speaking with them and going through the other options, I'm comfortable in recommending approval of the application.
It seems from Appendix A, we are quite a piece away from the Burnt River.
Through you, Mr. Chair, yes, that's correct. We're around 600 plus meters away from the Burnt River.
There are an awful lot of houses on the Burnt River, so yeah, I agree. Okay, thank you.
But they are saying, is this actually within the floodplain of the Burnt River?
Under, when I look at our legislation, the zoning bylaw doesn't have anything, and the official plan has it as significant woodlands in this area. But there's nothing that I could find under our legislation that would say so, but they do have their own mapping.
Yeah, I guess my concern is that if a regional conservation authority is saying there's an issue, and then we go ahead and issue a permit and something does happen, is there any liability with respect to the city of Kawartha Lakes with respect to that, knowing that a regional conservation authority has said, we don't agree with this because it's in a floodplain?
To you, Mr. Chair. So I can say, in this case, the KRCA, we do take in their comments into consideration. This is their extended planning agreement area. Obviously, my role as a planner is to take in their comments into consideration and see if, in my opinion, we can proceed, especially in this case because a permit is not needed. When I spoke with them, they were okay. They were basically proposing that the structure be relocated. But when we think about it from a practical lens, when we're looking on site, this entire area is already has gravel. If we were to move it to the rear yard, that's all green space. If we put it in the rear yard, that's a reduction in green space. I think that the proposed location is the most appropriate. That is my opinion as a planner. I can also speak here further with my director if that makes committee more comfortable.
Well, I'm not suggesting that we move it. I'm just thinking, would it be a good idea to red flag it maybe as a condition that, and mention the flooding and the fact that it has to be built according to the Ontario Building Code, or has to be graded, I guess, according to the Ontario Building?
To you, Mr. Chair, this is something I spoke with the supervisor, and he had said that this is just something that's automatically handled through the Ontario Building Code permitting process, so we don't need to put a condition.
Just makes me a little nervous, that's all. Ms. Archer.
Lisa, the planner, do we have any idea when the house and this shop were built? How many years ago?
Yeah, I do. I can, through you, Mr. Chair, I can take a look here. So the garage was built, I believe it was 1979. The house, I don't have that information, but I know the property owner, Mr. Polsum, is here, and his family has owned this property for generations, so I'm sure he has that information, yeah.
All right, anything further from committee? All right. Is the applicant here? Do you wish to speak to it, sir? I'm sorry? Yeah. Hit the button there if you would. You'll see a red light come on there.
Oh,
there
okay,
you go.
yeah.
And your name?
Robert Polson. Yeah, I'm the owner there. The house is built in '77, and I have a walkout basement there too. So that's, if the water's going to get this high, you got a lot of cottages to worry about back over on the river. It's not a problem. There'd be a pile of, they'll be floating down the mighty Burnt. It's
Well, I
it's
think
hard
the planner,
to believe.
I think the planner has addressed our concerns, so thank you for that.
Oh, quite welcome.
Are there any questions of the applicant? All right, being none, thank you, sir. We appreciate you taking the time.
Thank you.
Anyone here online wishing to speak in support of the application? Anyone here online wishing to speak in opposition to the application? Being none, committee, where are we? Councillor Yeo moves it. Do I have a seconder? Mr. Strangway? Any further comments or questions with respect to the motion on the floor? Councillor Yeo?
In favor.
Mr. Strangway?
In favor.
Ms. Richardson?
In favor.
Ms. Archer?
In favor.
Mr. Erickson?
In favor.
Mr. Finn?
In favor.
And I'm in favor. Your application is approved, sir. Oh, I'll get it. Anything under other business from staff? Director? No?
I will mention, thank you for the opportunity, Mr. Chair, very briefly, and your patience through today's meeting is much appreciated. This is longer than most of our meetings run. Thank you. You are volunteers. We value your time. Okay, so to the discussion around that very minor variance, several meetings or public meetings ago. It's a toughie. Member Strangway, you may be interested in seeing how the recently tabled Bill 17 legislation plays out. There is a proposed regulation that is looking to assign a 10% variation allowance to municipalities with respect to certain zone regulations like setbacks, that in the case of, again, this is all yet to be fleshed out. It's currently tabled with the Environmental Registry of Ontario. And so we are looking at that and providing some comments back, and any new information that we get, including what the result of the legislative changes are, we will make sure that the committee knows. It is not unlike some other zoning systems in Ontario that were at one point called development permit systems or community planning permit systems, where there is certain authority that's delegated to staff, typically a chief building official, to give the chief building official the authorization to make these types of judgment calls. It is an entirely new zoning bylaw, so it isn't just a motion, for example, that's passed by council. If going through this CPPS zoning bylaw process, it would be, again, an entirely public process to provide for this type of flexibility. There are a number of municipalities that have already developed these types of zoning bylaws, and it's certainly something the city would be interested in pursuing with council's blessing when the time comes to consolidate our urban zoning bylaws, those for Lindsay, Cajun, Omemee, and Fenland Falls. So depending on how the regulation shakes out, the new legislation, again, Bill 17, this may determine to what extent we need to look at a community planning permit system for a new zoning bylaw, because the Planning Act change would prevail and take effect immediately, likely. I mean, again, we have to see how this plays out, but we will keep the committee posted. We're all very interested. From a planning perspective, this is really advanced sort of thinking on the part of the province to go in this direction. It's got to be done methodically and within reason. Of course, just as a example here, 2 inches can, in some places, make all the difference in a dense, in a crowded or perhaps overcrowded neighborhood, whereas in a less dense, perhaps agricultural area, 2 inches on a building is obviously negligible. I mean, 2 inches in an urban area is probably negligible as well. But we would want to approach this type of latitude and variation that would be delegated to staff in a responsible way.
And Leah, thank you very much for that. I really appreciate that. And you can hopefully see a light at the end of the tunnel. Do we have, the other thing that I wondered is, as a council or as a committee, do we have the ability to waive the fee? Because the one aspect is the people having to go through this, sitting through the whole afternoon. The other aspect, I don't know, how much does a committee of adjustment application cost? Are we talking, what, $1,000?
Mr. Chair, sorry. Member Strangway, did you ask about the application cost for a consent application? I just wasn't clear if you had mentioned committee application.
So I look at an application like this and I say, how much did it cost these people to come forward for that application?
Bear with me just a moment, if you don't mind.
That's not fair.
We are talking about the consent application at 26 Edgewood, to be clear. Or, I'm sorry,
No,
we're
I'm
talking
talking
about
about the one at 181 at Louisa, the 2 inches.
The minor variance application fee is $1,550. All included.
So my question is there anything that would allow council or this committee to waive a fee in a situation like that?
The discretion to waive fees does rest with the director ultimately, and if the decision of the director was challenged, it would proceed to council at that point. We have not experienced that before, but that would be my expectation on how that would play out.
If I may, I would suggest that
if in fact there was any discussions relative to the fee or whatever, then they should be encouraged to approach council, should they not, rather than leaving it here with us? I don't know, where am I with that?
You're absolutely right. I would offer that this is the one committee or the one area that it wouldn't be appropriate to request the reduction or the waiving of the application fee for. However, it could be through the director or, as our chair has indicated, as a deputation request of council, if not satisfied with the decision of the director.
Anything further from staff? Oh, Mr. Erickson.
However, anybody could stand up and say, did the application go through the entire process? If so, that meant that all resources were used just like any other application, and therefore recommend it be waived, not be waived.
But that doesn't have anything to do with us. I would respectfully argue that if that's the case, then that, I suppose, could be considered as discreditable on staff's part, and that's what we have a council for, is to look at that. So they should be making a deputation to council and saying, we think this is wrong, blah, 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 and let council decide. But I would totally agree. I don't want anything to do with us playing around with fees, or whether there should be fees or shouldn't be fees here. I would vote against that. I'm one member of the committee, I realize that, but I would not support that in any way. I think that's a council decision, and the same as the official plan. They come here wanting to make changes with respect to how we interpret the official plan. The official plan says what it does, and if you don't like it, go to council and make your deputation to them. They're the ones that can change it, so we can't do anything about it here. Yeah, I forget about that thing. All right. Given that, then our next meeting is on Thursday, June 26th at 1 p.m. in council chambers. I would be remiss, Mr. Okawat, if I didn't say, Mr. Okawat. Hello there.
Can we rephrase the question?
Yeah, job well done, and we look forward to your future presentations. Well done.
Thank you, Mr. Chair. I appreciate it.
No problem. And to the director, that was a bit of a touchy one to start. We appreciate your assistance. You did an excellent job as well, so thank you for that. Anything further from committee? All right. Yeah, that was an easy one. All right, that being the case, I guess we're looking at an adjournment. Do I have a motion? Ms. Richardson, do I have a second? Mr. Finn, all those in favor? And that carries.